Good morning, everyone, and welcome to the Court of Appeals. Today is the second day of case call for panel one of this court's April 2026 session. My name is Dan Korotkin. I'm pleased to be joined here today by Judges Adrienne Young and Mariam Bazzi. Few remarks before we get going, but I'm sure for those of you who are familiar with the court, this will be familiar. So first of all, I just wanted to assure you we understand that these cases are very important to the litigants, to counsel. I want to emphasize that they're important to us as well. We have been working diligently on these matters for some time. We've had the benefit of your briefing, as well as the work of our excellent research division and chamber staff. So all of this to say we're familiar with the relevant facts, the pertinent law, and so we'll ask you today to focus your oral argument on what you feel are your most important points, specifically why you should prevail and what is critical for us to understand. Finally, we are hearing matters, as we do always, involving sensitive issues such as sexual assault victims, personal protection orders, and children. And because these proceedings are recorded, we ask you to please use initials rather than the actual name of any victim, child, or other vulnerable individual in those cases. With that, we look forward to your arguments, and we will get going right now. So the first case for today is case item number 17 on our docket. That's docket number 378748, Macomb Intermediate School District versus State of Michigan.
Good morning, Your Honors. May it please the court. Scott Eldridge on behalf of plaintiffs. I'd like to reserve 5 minutes for rebuttal, if I may.
Sure. We'll ask you to keep your own time, but that's absolutely fine.
Fair enough. Thank you. Your Honors, rushed legislation often results in bad legislation. In this case, it resulted in unconstitutional legislation. The legislature's hasty passing of Public Act 15 of 2025, which includes the problematic privilege waiver language at issue here, embedded in section 31 AA subparens 9 of the statute, resulted in language that violates the Michigan Constitution in multiple ways, as we've outlined very clearly in our complaint, in our lower court briefing, and in our briefing in front of this honorable court. I believe our briefs have fulsomely addressed all of the issues, and I look forward to answering any questions that you may have about those issues. I'm going to largely rely on our briefing, but before I invite questions, I'd like to make 2 points and emphasize 2 things before I invite questions, if I may have the court's indulgence. The first is, I'd like to put your decision in this case a little bit into context and what it might mean. You know, often when we're asking appellate courts to rule on really important cases like this one, we have to think about what does it mean for future litigants? What does it mean for future cases? What does it mean for Michigan jurisprudence? And I think it's important for all of us to understand kind of what a decision in our favor would look like. A decision in our favor would not require this court to make some sweeping, broad pronouncement that limits the legislature's power in any way. We're not asking this court for a ruling in our favor that would invent some new rule of law. We're simply saying and asking this court to, if the legislature wants to move down this path from a policy and conceptual standpoint, we're asking this court to simply say they need to start again. They need to reset and redo this statute, if they want to, in a way that complies and stays within the confines of the Constitution. There is a way for the legislature to go back to the drawing board and live to fight another day, if you will, by making a statutory provision that is not void for vagueness, that complies with Article 4, Section 24 of the Constitution, and that doesn't intrude into the sphere of authority of the judiciary. Those, of course, are our claims in this case, that it violates those different aspects of the Constitution. And all we're asking you to do is declare, and by reversing the Court of Claims, and declare that this privilege waiver is unconstitutional. That doesn't mean the legislature can't reconceptualize whatever goal they're trying to achieve. We can debate from a policy perspective whether it's a good idea or not. I know that's not your role, that's not my role.
You say get rid of the privilege waiver. Are you talking about the actual privilege waiver sort of flanked on either side by commas? And so then the statute would still have the subject to a comprehensive investigation, strike, and must agree to comply with a comprehensive investigation?
Yes, Your Honor, almost.
Okay.
I think a fewer words. We're asking you to strike even fewer words than that. Basically, this is in subparens 9 of Section 31AA. After it's the phrase that starts, quote, must affirmatively agree to waive any privilege that may otherwise protect information from disclosure, end quote. That's the line that we think you can.
Oh, I see. So must be subject to a comprehensive investigation in the event of a mass casualty event and must agree to a got it.
Otherwise, there's nothing that triggers the comprehensive investigation. And to be very candid, if that clause that I just read and quoted that contains the waive any privilege language wasn't there, we wouldn't be here. So we're not asking for all of 31AA subparens 9 to be stricken. And while we take great, we have great concern about the vagueness of the definition of mass casualty event, as we, spend a lot of time in our briefing on. But again, if the privilege waiver language wasn't there, we wouldn't be here. My clients, the plaintiffs in this case, aren't concerned about being subject to a comprehensive investigation. They just are upset about having to be forced to waive any privilege, whatever that means, in any context. We don't know what those are necessarily, which is why we have vagueness.
Well, they're not really forced, right? It's a condition of receiving these funds.
Well, one of our counts in our complaint and our arguments is that is an unconstitutional condition. It's not really a voluntary choice. The state is dangling hundreds of thousands of dollars, if not millions, for some of these school districts in front of their face, saying you have to give up your substantive due process rights in order to do it. That's an unconstitutional condition, as we briefed in our.
We do know that some school districts have made that choice. Right?
Some have, yeah, some have, and it's a difficult choice. Most schools districts that as far as I understand, that have, it's gone to a full debate and vote to their school boards, and they're making a really tough decision. Do we give up waiving privileges in unknown contexts that we can't predict because of the vagueness of the statute, or do we take this money that they're dangling in front of us? And a lot of
do you think it would help matters if this court, in its opinion, well, let me go back to the court of. Do you think it helps matters that the Court of Claims interpretation of what the statute meant, sense that before a court renders its decision, the school districts are going, oh, we don't even know what this means. It's hard to know what's and now if we have a court decision that says, well, we actually interpret these statutory terms to mean X, Y, and Z, this provides some more certainty for going forward.
No, I think the answer to your Honor's question is no, and it actually leads me to the second point I was going to open with. But before I get to that second point, a couple of things to address your Honor's question. The Court of Claims didn't address a number of issues that we had briefed about the vagueness of the language. And as a result, remains entirely vague and uncertain as to what it means. And that, in one example, is the court did not address at all the temporal scope of the privilege waiver. The statute is entirely silent on, like, when does this waiver take effect? And the Court of Claims said clearly it applies to any privilege. So that's the attorney-client privilege, work product privilege, statutory privileges. When does the waiver take effect? If there's a mass casualty event, and I, as an attorney, gave my school district client advice 10 years ago about dealing with mass casualty events. Is it waived going all the way back to the inception of that legal advice 10 years ago? Is it waived at the date of the mass casualty event? And how long does the waiver last? Is it in perpetuity? Don't know the answer to these questions. And if I have a client asking me, what's the answer to that question? I'm going to have to say, candidly, I don't know, because the statute is so vague. So the Court of Claims, Your Honor, didn't address that issue at all. And we think that's problematic and doesn't resolve it. But I had alluded to the fact that your question prompted maybe kind of a nice segue into my second point, which is what the Court of Claims did is attempt to come up with examples that the Court of Claims said this fits into the definition, in my view, therefore problem solved, right? We don't think that's the right way to look at it from both the Michigan jurisprudence and federal jurisprudence on addressing the standard for void for vagueness cases. So the state places a lot of emphasis on the standard, and the Court of Claims recited this standard in its decision, and that is the standard that the plaintiff in a void for vagueness claim must show no set of circumstances exist under which the statute would be valid. But the case law upon which the court relied for that proposition, including that the state cited, is not a void for vagueness case. In the federal case law upon which that Michigan case law is cited is not a void for vagueness case. And actually, as recently as 2015, the U.S. Supreme Court issued a decision that we did not cite in our brief, but if you will indulge me again, I'd like to discuss it briefly. It's Johnson versus the United States, 576 U.S. 591 from 2015. It was a 7-2 decision addressing this very issue, rejecting this idea that in a void for vagueness case, the no set of circumstances standard should be applied. In fact, what the Supreme Court said was, quote, "Our holdings squarely contradict the theory that a vague provision is constitutional merely because there is some conduct that clearly falls within the provision's grasp," end quote. That's exactly what the Court of Claims did in evaluating the void for vagueness claim here. The Court of Claims just said, well, I can think of a hypothetical that falls within it, therefore you lose, and it's not vague. The Supreme Court then goes on in that Johnson versus U.S. case to say, quote, "The supposed requirement of vagueness in all applications," which is akin to the no set of circumstances test, "is not a requirement at all, but a tautology." Goes on to say, quote, "If we hold a statute to be vague, it is vague in all applications and never mind the reality," end quote. Michigan jurisprudence in this arena has followed federal law. Again, we try to trace back the origin of this no set of circumstances test for making constitutional facial challenges. And it dates back to a case in 1997 that relies on a previous U.S. Supreme Court, neither of which is a void for vagueness case. And so the U.S. Supreme Court has clarified that if we're talking about void for vagueness cases, we don't rely on this no set of circumstances. And so the fact that we can identify circumstances or scenarios that fall within the statute's parameters doesn't solve the vagueness problem. We still have an unknown number of uncertain scenarios that could trigger it or could not trigger it. In fact, the Court of Claims even identified an example. It was the example about if a set of bleachers at an athletic event were to collapse and result in fatalities, said that could trigger the statute. Even the Court of Claims wasn't confident in that one. And so this is one of the problems that we think, one of the serious problems with the Court of Claims decision.
What would be wrong with waiting until such an event occurs and saying, this is a situation where we could not have confidently predicted that the statute would apply. So therefore, not on its face, but as applied to this situation. So therefore, we'd like to reinstate our privilege.
Unfortunately, if you rule in favor of the state on this case, you're going to see a lot of us. All right, you're going to see a lot of lawyers in this very courtroom
Doing that
very
Okay.
thing, fighting over it.
But that's sort of the point with having two avenues for constitutional claims, facial and as applied. So I think that it almost does too much to define vagueness the way that you're asking us to, because you basically collapse as applied and facial challenges. You're saying that because Judge Patel said, here's one example that may or may not fit under this, therefore it's vague. But to Judge Koropkin's point, what you're talking about is something that might better be suited for an as applied challenge.
Well, certainly void for vagueness claims on an as applied basis is a thing. That's a recognized claim under Michigan jurisprudence and federal jurisprudence. And I want to maybe correct something. Maybe I misspoke earlier based on your question, Your Honor. The Court of Claims judge said, I think the opposite of what you said, which is, I can think of examples that fall within the statute, therefore it's not vague, not therefore it is vague. But here's what the Court of Claims didn't do, in addition to other problems that I've recited and in our brief, is the Court of Claims went on to say, this is there's no set of standards or no set of circumstances standard that we have to apply. And then the court recited the two elements for a typical void for vagueness analysis, but then didn't apply that analysis whatsoever. And so what I want to remind the court of here is that what the analysis is remember, it's a two-step analysis under a void for vagueness. There's two items and considerations that we have to examine. One is, does the statute put the citizenry, people who have to comply with it, on fair notice of what is legal conduct and what is illegal conduct? And we don't believe that this statute comes close to doing that. I can't advise a client about when they are waiving privilege, for how long, under what circumstances, under this language at all. And I don't think it puts the public on fair notice as to what is legal or illegal conduct. That's one aspect of the void for vagueness analysis. The second aspect is, does it place the judiciary, law enforcement, juries on notice and provide parameters to avoid and prevent arbitrary and discriminatory enforcement? We don't believe it does. Someone is going to have to make a determination about whether a privilege is being invoked properly or not, because maybe it's been waived or maybe it hasn't. I'm not sure who does that initially. Maybe it's law enforcement, maybe it's the Attorney General's office, because remember, it's a crime to violate the School Aid Act. And this is one of the reasons why we've emphasized that is because what the U.S. Supreme Court tells us, what Michigan case law tells us, we've cited in our briefing, is that if there's a criminal component, criminal penalty tied to the end of what we're talking about, then the definiteness with which the legislature has to craft its legislation is heightened, and the standard and the scrutiny is heightened. And here, if a superintendent, any other school official who's responsible for running the school district invokes a privilege that they unknowingly waived because it was in some bizarre circumstance that nobody ever thought about because of the vagueness of the language, have they now subjected themselves to potential criminal penalty for improperly, according to someone who might arbitrarily enforce this statute, because they've invoked a privilege that someone else thinks had been previously waived unknowingly? That's why this language is so problematic and why heightened scrutiny of it is necessary by this court, but also more definiteness is required by the legislature. And again,
I'm confused by your requested waiver or your requested remedy and these arguments, because you want us to preserve the words "in the event of a mass casualty event." And that is the same language that the Court of Claims has said temporally limits the waiver. And though you do present arguments as to why the mass casualty event definition itself may be overly broad, or vague. The fact that you want us to preserve the very language that is limiting and cuts against your void for vagueness argument seems like a mismatch to me.
So
It seems like we would have to find mass casualty event as also vague, but yet you're asking us to preserve it.
It's a good question, Your Honor. Our argument is that the waive any privilege clause coupled with the mass casualty event is what is the problem for the individual clients that I represent in this matter. Remember, the individual plaintiffs are school officials, superintendents, or school board members. They have this due process constitutional right here. They're the ones that would invoke the privilege, right? So that's the language that applies to them. Who's determining whether to make or to instigate or initiate a comprehensive investigation in the event of a mass casualty event is not my clients. That would be the governor, because the statute said the governor, excuse me, gets to appoint someone to conduct an investigation. And so that's why we're saying we are only concerned about the privilege waiver provision. That is that clause that I read to Your Honor earlier, because that's the one that implicates the individual due process rights. And so we think the rest of it can survive. I mean, we still don't like the mass casualty event language, but it's only constitutionally problematic from a due process standpoint when it's coupled with the privilege waiver. That's why we're connecting those.
So you've mentioned a couple of times the individual due process, right? Are you referring to the idea that it's unclear whether the privilege waiver is just for the privileges of the that you're saying?
I'm not, that's not why I'm saying it. I'm happy to address that issue.
Who's like, why is there an individual due process issue?
Well, because
Or is it because someone could be charged with a crime for invoking it on behalf of the school?
Exactly right.
Okay.
It's individuals that have to make the decisions about whether to invoke a privilege. And if they make a choice to invoke the privilege and they guess wrong because they unknowingly waived it by accepting this money in 2025, and maybe this is 25 years down the road, someone says, no, that was waived 25 years ago. And I invoke the
additional
privilege.
Case law that precludes the criminal portion of this statute from being interpreted as a strict liability offense. I mean, there's case law and there's statutory law that requires the reading in of some form of an intent requirement. So the idea that it's just a trap door for strict liability doesn't comport with the existing case law or with like MCL, I think it's 8.3 that requires us to read. They talked about it in People v. Tadgerson. If a statute doesn't clearly state a mens rea requirement, then you should read in knowing or recklessness. And so I guess I don't follow the follow how the language of this statute creates the sort of dramatic picture you've painted with criminal liability.
In fact, Your Honor, I think my example was just that an example. I think even if a superintendent or other school official makes a measured determination about, yes, I'm going to waive this or I'm going to invoke this, and I'm confident that I'm invoking it properly, I still think there's so much uncertainty because of the vagueness of the language that they are still going to potentially be subject to the criminal penalty. And again, it's that criminal penalty that requires the heightened scrutiny. And we cited a case from the Eastern District of Michigan from a good number of years ago, maybe 10 years ago or so, called Taylor versus Johnson, where school officials in that case sued the Secretary of State over a change to the Campaign Finance Act, Section 57 of the Campaign Finance Act. And the court in that case enjoined the enforcement of it under this very theory that we've presented under the due process clause, that is, by saying it because there was a criminal component to it, that didn't have knowingly language that Your Honor is describing. Nonetheless, because there was a criminal penalty attached to the end of this statute, that it was subject to heightened scrutiny, and that heightened scrutiny resulted in striking it down. So I don't think I'm not suggesting it just because it's a strict liability, or it could be under certain circumstances, strict liability, criminal penalty, that solves the problem, or deems it constitutional. But these again are the things that we're going to be fighting about for years if we don't strike it down as unconstitutional now. I'm happy to answer any other questions. I made the two primary points that I wanted to. I'm happy to answer any questions Your Honors have about any of our theories, including Article 4, Section 24, or the separation of powers argument. But if not, I will rely on my briefs. I look forward to some brief rebuttal.
I'm going to ask something about the Article 4
Yes.
title object stuff. So this is another one where the proposed remedy is difficult for me to kind of wrap my head around with this. So, the any privilege waiver is a condition to getting funding. And there's case law that says it's not a title object violation if you're putting conditions on funding. To me, the harder question is about the comprehensive investigation, because that's not funded by the funds that are allocated under the School Aid Act. And it's, like you've pointed out in your briefing, sort of this external entity selected by the governor doing the investigating. So I guess kind of help me again understand your proposed remedy in light of the fact that conditions on funding are generally recognized as appropriate under case law, and that this separate thing that you argue we should preserve feels the least appropriate in this title statute.
Thank you, Your Honor. The case law that you're referring to that talks about conditions about as a prerequisite to receiving funding, those kind of conditions that are addressed in that case are very different than a wholesale sea change of waiving privileges in unknown circumstances. Any privilege, attorney-client privileges, work product privileges, statutory privileges. That's not the same kind of condition that those other kinds of cases we're talking about. Those were, you have to account for the money, right? You have to be subject to audit. You have to report.
So sorry to interrupt,
yeah.
but even if I were to agree, and I think you're right, that's still getting at vagueness, right? Because at the end, the case law says you can have a condition. And what you're telling me is, whoa, this condition is categorically different. It's very broad. Well, that kind of falls back into void for vagueness. You can still have a condition on funds and have it fit under the house of funds. So that doesn't necessarily get at your title object.
Well, sorry, and maybe I'll just take a second to clarify. I'm not saying it violates Article 4, Section 24 because it's so vague, although I think the vagueness of it contributes to the lack of germaneness between the privilege waiver and appropriating school aid funds to schools. Our argument is a little more simple than that. It's just that mandating, forcing a waiver of all privileges in all circumstances and unknown circumstances is not germane at all to the distribution of funds, and is not akin at all to the kinds of conditions that courts have said are appropriate and don't violate Article 4, Section 24 in connection with appropriation bills. Again, which are things of like auditing and reporting and counting for the money. The waiving privilege has nothing to do with those sorts of things, right? It has nothing to do with accounting for the funds or reporting on your use of the funds.
And how does that not equally apply to the entire investigation, which you say in an ideal world is language that remains?
Well, we think in the void for vagueness context, you can carve out.
Got it. Okay.
And for Article 4, Section 24, though, I think I can make this same argument. I think we do make the same argument that the comprehensive investigation is also not
Has got to go.
germane to the germane to just the bill, the primary subject of the bill, which is to appropriate and distribute school aid funds.
So we keep comprehensive investigation if we agree with you on void for vagueness, because we just get rid of any privilege. We don't keep it under title object.
We would be happy with a ruling that that you strike the waiver privilege, waive any privilege language that I described earlier, even in the Article 4, Section 24 context. We think
That's what you're challenging.
that is ultimately, that's
Someone else might have issues with the other thing, but what you're challenging is
Yeah.
like I said earlier, if that language about waiving privileges was not in this statute, we would not be here. So with that, Your Honor, I'll yield the lectern to my friends on the other side and look forward to a short rebuttal. Thank you.
Morning, may it please the court. Assistant Attorney General Adam DeBear appearing on behalf of the state of Michigan. At my council table is Assistant Attorney General Drew Jurgensen. He's here on behalf of the Department of Education and the State Superintendent of Public Education. So if the court has any questions for specifically with respect to the process or things that the MDE administers, Mr. Jurgensen will be able to address those. But speaking with regards to the constitutionality of the underlying statute, I think it's important to first focus on the plain language of Section 9. Section 31AA subsection 9 says to receive funds under this section, a district, an intermediate district, a non-public school, or the Michigan Schools for the Deaf and Blind must agree to be subject to a comprehensive investigation, must affirmatively agree to waive any privilege that may otherwise protect information from disclosure in the event of a mass casualty event, and agree to comply with the comprehensive investigation. So the only entities that have to waive anything are districts, intermediate districts, non-public schools, the Michigan Schools for the Deaf and the Blind. Out of plaintiffs here, the only applicable entities that have to waive any privileges, I believe, are school districts and intermediate school districts. There is no requirement for any individual to waive a privilege. And there's also no non-public schools that are a party to this case, and the Michigan Schools for the Deaf and Blind aren't subject to this case. It is only public school districts and intermediate school districts. And to that end, with respect to the void for vagueness challenge, void for vagueness doctrine sounds in due process guarantees, and the due process guarantees come from the Bill of Rights, and the Bill of Rights don't generally protect government from government. They protect individuals from government. So to the extent that there is the ability for public schools to bring a constitutional challenge for a violation of their constitution, I would submit that the school districts themselves don't have those constitutional rights to protect. The individuals do, but again, neither the legislature nor the Department of Education can get together with the school districts, arrange for a contractual waiver of privileges, and affect. So A and B can't get together and affect the rights of C is the typical principle I would promote here.
Well, I think what Mr. Eldridge was saying is that an individual could be charged with the crime of violating the act by making a decision on behalf of a school district to waive or not to, I guess, to not waive a privilege. And if that's the case, then there's a liberty interest by the agent, the administrator, the superintendent, that could be implicated if this language is unconstitutionally vague.
Perhaps under that statute, there's a scenario in which a school accepts funds. There's a mass casualty event. A comprehensive investigation is sued. There's a demand from the investigating entity to the school district for production of records, which the investigating entity would be entitled to. And if that administrator rejected that privilege on behalf of the school district, there is a world in which that's possible. But what isn't possible under the statute is for an individual administrator to be subject to criminal penalties for invoking their own constitutional privileges. Because again, this statute doesn't touch those privileges. And in theory, under binding case law, it can't. But it doesn't, and it also can't. So the only hypothetical scenario would be to have a school district accept the funds and to have the administrators not comply with the waiver request. That's the only foreseeable potential of criminal penalty. But again,
I do think, to be fair, I think that's kind of what the hypothetical was, right? It's an individual human, but with their superintendent hat on, saying on behalf of the district, we decline to provide any of these student documents. And then the response is, well, then you can be prosecuted.
and I think Your Honor is correct. I don't have the cases. I didn't research the matter beforehand, but I'm not sure that if the school district makes a good faith objection to the production of records, that the requisite mens rea would be satisfied in order to move forward with prosecution. What would happen in that case would be the investigating entity would commence an action in presumably the circuit court for which the school district is located and seek an order compelling the production of those records. But criminal prosecution in and of itself wouldn't apply to a good faith objection from a school administrator. And when you look to the language, it's in section 9A, what the comprehensive investigation is supposed to assess is any factors contributing to the incident. So to the extent that there is an overbroad request for production, again, this court knows that facial challenges are typically disfavored and as-applied challenges are preferred. There would be an as-applied challenge that the school district or the entity receiving the request for documents could bring at that time. But there's no possibility under this statute in which a good faith objection to the production of records could result in criminal penalties. A bad faith one, in theory, could, but it's hard to imagine as we sit here today before any enforcement activities have been involved, before there's been, in my mind, any invocation from the governor to direct a comprehensive investigation for mass casualty event. It's hard to imagine what that circumstance would look like. With respect to it being an unconstitutional condition on fundings, I suppose there's a world in which, because under Article 8, Section 2, the state is supposed to maintain a system of public education that's free of charge. So in theory, you couldn't condition the receipt of all public funds for schools on this waiver of privilege. That might be a violation of the unconstitutional conditions doctrine. But when you look to the statute, the funding comes from, it's in subsection 1, comes from this money that's at issue here comes from the funding appropriated in section 11 of the Public Act. And when you look to section 11, approximately $100 billion was appropriated in fiscal year 25, and approximately $100 billion was appropriated in fiscal year 26. So of that collective $200 billion, or even if it's 100, if we're looking at a specific school year, the amount at issue here is 321 million. So it's less than 0.5% of all the funds, and it is specifically targeted to the student safety and student mental health aspect of the funding. So again, I don't think an unconstitutional condition can arise from conditioning money that goes to the public schools, because it's such a small percentage of the funds that go to the public schools. Judge Koropkin, you asked earlier whether a judicial interpretation would help, whether the Court of Claims interpretation helps. The state submits that it was a thorough, well-reasoned, well-researched opinion that does outline the scope of the waiver, how the process would look like, and it provides examples for what could trigger a comprehensive investigation and what would happen as a result. But it's not binding as a general matter because it's a trial court opinion. But if this court were to issue a published opinion affirming the trial court, this court's opinion would be binding, and therefore it would be helpful on school districts that might, because in theory, there's going to be a fiscal year 27 school omnibus act that might have a different privilege waiver attached to it. But this court's opinion, if it were published, would be binding, and it would provide an additional basis in the law for the receiving school districts to make sort of an educated decision with more background on whether or not to accept funding. So I do think if the trial court's opinion doesn't help, this court's published opinion affirming the trial court certainly would.
I think the trial court's judgment actually only applies to this year's appropriation, and so
Right, because
unless there's a published opinion out there, next year's appropriation, it's just everything just resets and starts over.
right, but the basic concepts, if the framework where for a school to or for a district to receive funding, this type of funding has to agree to essentially what the aim, when you look at the statute, it's the idea that school districts have to provide the records and can't sort of hide behind the privileges that have sort of stalled all the recent investigations into the mass casualty events that we are aware of, where they actually have to provide the records and there can be some investigation to determine how best to move forward. That's what the goal of the statute is. So if there's a condition on the receipt of that money that requires compliance and takes the way, you know, with a voluntary choice, takes away the ability to object based on privileges, this court's opinion would still be helpful there. But yes, if there's different language with respect to mass casualty events, obviously it's less limited in that context. But I do think the basic principle would be helpful in the event that this sort of similar framework occurs in the next fiscal year. And again, with respect to the idea that void for vagueness challenges are different than other constitutional challenges, I would point this court to Oakland County versus State of Michigan. It's a 325 Mishap 247. And the language there is to make a successful facial challenge to the constitutionality of a statute. The challenger must establish that no set of circumstances exists under which the act would be valid. And I think that applies here. That's a 2018 Court of Appeals opinion with respect to facial challenges generally. Whether there's a distinction between void for vagueness and this case, you know, I'm not prepared to go deeper to in further detail on that issue today, but it's a broadly applicable opinion with respect to facial challenges generally. And there are, of course, and I think that the plaintiffs' counsel would agree, there are, of course, situations in which you would have a mass casualty event that could be predicted, because we've dealt with one in 2023 or 2024. I can't remember the exact year that it most recently happened, but we've dealt with one. That's what everyone envisions when they think of a mass casualty event. And it would be a clearly identifiable instance, which would justify the initiation of a comprehensive investigation by the governor and set up the investigatory process. And so there is clearly at least one example that would be constitutional. To the extent that the court's concerned with the vagueness of any of the definitions that are involved in the, you know, sort of the sub-definitions to mass casualty event. I think one of the definitions that plaintiff challenges is the use of the word significant. Words like significant and serious are used oftentimes in the legislature. The Tort Liability under the No Fault Act talks about the serious impairment of a major bodily function. There have been case laws, and it's codified in the statute now, but the Supreme Court and the Court of Appeals were able to determine what that means. I would submit that significant is not that much more different than serious, and that the Court of Claims arrived at the correct definition. Generally speaking, with void for vagueness, the test is fair notice, such that a person of ordinary intelligence would be able to predict what they might be waiving. Now, the waiver itself is not vague, it's broad. It's any privilege, and it's any privilege that the holder of the privilege, well, that the receiving entity holds. Can't waive the privilege of another person, but any privilege that the district has, whether it be attorney-client privilege, whether they possess information from their attorneys that could be classified as work product, and even in the school counselor privilege, not to the extent that it's testimonial, but just the delivery of the information in the school's possession. Any testimony or any privilege that the receiving entities hold, they're waiving here. There is nothing vague about that. The only potential uncertainties are whether certain instances could classify as a mass casualty event. And I would submit that the Court of Claims appropriately analyzed each of the sub-definitions. But if there is one sub-definition that this court finds problematic, that's where it could strike for vagueness. It could strike a sub-definition of the mass casualty event. Because there's one definition that is not vague, and that's an incident that results in fatalities. Court of Claims correctly analyzed the meaning of fatalities and that it requires plural because it would be contrary to the legislature's manifest intent by defining mass casualty event to include just one injury. So I think if there are more than one fatality, if there's more than one fatality, it's clearly a mass casualty event, and I don't think there's anything vague in there. To the extent that this court is interested in vacating or striking anything as void, it should focus on just some of the sub-definitions in the definition of mass casualty event, because the waiver of privileges is in no way vague. It's just broad.
What about the temporal scope issue that Mr. Aldridge raised?
Well, two points. So the receipt of this, the waiver of privilege is tied to these funds, and these funds were appropriated in the fiscal year ending 2026. So when these funds are gone, I don't know that this statute is, applicable. If the court, for the general omnibus boilerplate or for the budget bills that fund general government, you typically don't find those in the compiled laws. But for the State School Aid Act, the State School Aid Act is updated sort of every year that there's a new condition, different positions are removed. So if you actually go to, MCL 388-1631 AA, you'll see this language from the public act there. But when there's a new public act for the next year, the language is going to be replaced. So I think that comprehensive investigations are limited to the sort of the applicable fiscal year. The temporal scope that Mr. Eldridge was addressing, I believe, was, well, how far back does the ability to subpoena records go? Two things. I think that's more appropriate as an as-applied challenge as opposed to something that we should address here. And if it's brought up on an as-applied challenge, you just go to the language of the statute that I referenced earlier. It really, the subpoenaing power of investigative entities only goes to factors contributing to the accident. So to the extent that I'm seeking information that, the school received from their attorneys 25 years ago, I might be hard pressed as the investigative entity to demonstrate that that's one of the factors that led up to or that contributed to the mass casualty event. So the temporal scope, I think, is governed by the language of the statute would be a shorter way to answer your honor's question. And then lastly, to address Judge Young's questions with respect to title object, I think a common condition on the receipt of any funds from any public entity is auditing, right? Like whatever the entity is, particularly if it's the federal government, if you're receiving federal funds, there's the possibility that you're going to be subject to an audit and that the auditor has the ability to access books, records, billing statements, et cetera, to determine whether the funds were properly used. The comprehensive investigation is very similar here. It has the same basic components of an audit. The only thing that it has in addition to an audit is it can subpoena employees for interviews. But again, those employees, to go back to the earlier point, still have the ability, if they've consulted with an attorney out of fear for criminal prosecution or future civil liability, they still have the ability to not testify and invoke their own Fifth Amendment rights or their own attorney-client privilege for any confidential communications that occurred with their attorney. But this can
if a school district does not agree to accept the funds, none of this applies to them. Is that
correct?
Right?
And Mr. Jurgensen might be able to address how many schools did accept and how many didn't. My understanding that it's somewhere around half, but for those,
because there's a slightly strange part of this statute in the sense that in the main section of subsection 9, it says that they must agree to receive funding. They must agree to be subject to a comprehensive investigation.
Right.
Okay, so that seems to tie directly the funding to the comprehensive investigation.
correct.
Then below that, there's some stuff that sort of indicates, you could read it to indicate the investigation is going to happen regardless. And it's only a matter of whether, it's only a question of whether the school district has waived its privilege or not. Like the stuff that says, the governor shall designate an appropriate person. The investigative entity designated shall prepare a detailed report of its findings. Is that going to happen? That seems a little bit more off to the side and not really a funding condition to me. And that might be where some of the title object issues come in.
Well, I think that sticking with the comprehensive investigation, because I do think that the school districts who don't accept the funding might still be subjected to a comprehensive investigation. They can simply invoke whatever privileges that they have, and they haven't waived any of their underlying rights, so it might end a little differently. But the condition itself to have a comprehensive investigation, I would submit, still is related to the funding, because this funding is designed to promote the student safety and student mental health. And it's a significant influx of taxpayer dollars with, approximately $321 million being contributed. And it's an important issue to the state, to parents who want to send their kids to schools and make sure that that their kids are safe when they're at their schools. There is a legitimate government interest to want to know, in the event that something terrible happens again, how can we address this going forward? And I think that some of the areas in which previous investigations have been forestalled was likely the impetus of this legislation. But that condition to have an investigation is simply trying to assess, were the funds that were designed for student mental health and student safety, were they well used? Could they have been better used? And how can we use those funds in the future? So I think in that sense, it is germane to the underlying condition. And when you go through the entirety of this, school omnibus budget act, there's a lot of conditions for reporting and information off the receipts of, public funding. And this is just another one that I would submit is similar to the audit, and for that reason, sort of germane and something that you could expect. But unless the court has any other questions, I would ask that the court issue a published opinion affirming the trial court, and I'll turn it over to my colleague, Mr. Jurgensen, who's representing the MDE and the State Superintendent for Public Instruction. See if the court has any questions. Thank you.
Good morning. May it please the court, Andrew Jurgensen on behalf of the MDE and the SPI.
Mr. Jurgensen, you're sharing time, so you only have a few minutes.
Yes, I was just going to say, I plan to be very brief here in recognition of your other cases and MDE's limited role in this case. 2 quick points. First, I wanted to update the court that since it denied the late February motion filed by the appellants regarding or requesting the freeze of the funds, if you recall, the MDE had made partial payments up to that point. Once the court denied that order, MDE then issued the remainder of the funds in one lump sum. That was done on March 20th. So those funds are now completely distributed to all of the schools that state opted in and receive funds under this section. The second point I just wanted to briefly mention is that obviously MDE's concern here is simply concerning the relief. We take no position on the constitutional arguments. The appellants in one of their briefs mentioned that we're asking for meaningless relief, essentially, that if we argue against their clients, the appellants receiving 31AA funding for this year, asking this court to enforce the stipulation between the parties in the Court of Claims and seeking finality here as we near the end of the school year, that somehow they would have no meaningful relief available. I think that argument rings a little hollow given the importance of their concerns regarding the constitutionality issues and the fact that the provision could be included in next year's State School Aid Act and beyond. In short, there's something still left for them to fight for. And if this court were to reverse, but were to not touch the funding that's been allocated this year, that relief, I would imagine, would still be meaningful to the appellants. So unless this court has any other questions for me, I will take a seat. Thank you.
Mr. Eldridge, you have about 4 minutes. Thank you. Go ahead.
Regarding the remedy that we seek, we do think this court is equipped and has the authority to grant the relief that we're requesting, despite what the MDE says, for all the reasons we've stated in our briefing. But another option for this court is, if you rule in our favor on the substantive issues, you can always remand to the Court of Claims to figure out an appropriate remedy, including potentially having a hearing on it if necessary. I want to touch on a few things, and this my friend on the other side from the state mentioned. First, to be clear, we understand the school districts themselves and the ISDs themselves don't have substantive due process rights. It's the individual plaintiffs, the school officials that are bringing those substantive due process rights under the void for vagueness doctrine.
You have plaintiff as the individual plaintiffs are superintendents.
Superintendents, school officials, school board members, things of that nature, Your Honor. Mr. DeBear touched on this idea of individuals versus districts. I understand what the Court of Claims said, that the individuals themselves aren't waiving any sorts of privileges. But one of the things the Court of Claims did not address is a scenario that we briefed, which is what happens, which is not uncommon, when defense counsel like me is hired to represent, say, in civil litigation or in connection with a comprehensive investigation, to represent both the school district and the superintendent in their individual and official capacities. I'm the same lawyer for both. That happens all the time. What happens if that superintendent is questioned by the Attorney General's office or any other investigator and says, well, I'm invoking my privilege, I'm not answering those questions? And the investigator says, well, the school district, you're the superintendent, they waived the privilege. You have to answer the question on behalf of the school district. And the superintendent says, no, but I have my own attorney-client relationship with that same lawyer and I'm not answering the question. Did that person just commit a crime? I don't know the answer. And that's the problem. And so those sorts of scenarios aren't answered. And I think the fact that, Mr. DeBear got up here and provided some colloquial with Your Honors about certain circumstances may be covered, maybe not covered, kind of proves the point, right? There is no answer to a lot of these questions, and that is the problem. And the fact that we can identify some circumstances that might fall within the statutory language is not the test, as we've spelled out earlier. I'm happy that Mr. DeBear is very confident that a good faith objection to a subpoena of some sort would not result in criminal penalty. I don't know that I'm so confident under this statute. The fact that a crime or a criminal component exists here is not necessarily why there's a due process problem. There's still a void for vagueness problem, even if that criminal component isn't there. The fact that the criminal component is potentially there at the end of the day only heightens this court's scrutiny of the statute. That is the issue with the criminal piece. And last, Your Honor, regarding the temporal kind of scope of this, I don't think that question has been adequately answered or addressed, and we think that remains uncertain. The statute just is not clear at all about the temporal scope of this privilege waiver. And as far as whether it survives this year's funding cycle, I think I even heard Mr. Bear say and admit that he wasn't certain that it would, and it's not clear. And it's not. There's nothing in the statute that says this privilege waiver only applies during this cycle and in connection with these funds. It doesn't say anything about being connected directly to these funds. It just says in the event of a mass casualty event, you've waived your privileges, period. That's all it says. And then again, I didn't hear much from my friend on the other side about how the privilege waiver is somehow germane to the underlying purpose of the statute, which is to appropriate funds. He'd spent a lot of time talking about the comprehensive investigation, but I didn't hear anything about the actual privilege waiver being germane. And we think that's the reason why there's a problem under Article 4, Section 24. With that, Your Honors, I will rest on our briefs and ask that you reverse the trial court's decision and declare this privilege waiver unconstitutional for all the reasons I've stated today and in our briefs.
Thank you very much.
Thank you.
Thank you all. That case will be submitted. All right. The next case we're calling is item number 18, docket number 374852, People versus Peter Timothy O'Brien.
Morning, Your Honors.
Good morning.
Habib Gaddis, attorney on behalf of the appellant Peter O'Brien. Please, the court. The question presented in this case is whether the rationale exercised by the trial court in its guideline departure included factors otherwise embodied in the guideline score. And if so, whether the departure was justified by the seriousness of the offense and the background and character of the defendant. Stated alternatively, or possibly more concisely, is were adequate reasons given by the trial court for the departure in this case. With regard to sentences that depart from the guidelines, the People in recent decision, People versus Bursick, citing People versus Dixon Bay, and I believe it's at the decision of Bursick was this previous month in March, and I believe the court's docket number was 362727, decided March the 9th of this year. Citing Dixon versus Bay, the court addressed the standard of review and stated as follows. We review whether a departure sentence is more proportionate than a sentence within the guidelines range, including whether the guidelines accurately reflect the seriousness of the crime, factors not considered by the guidelines, and factors considered by the guidelines but given inadequate weight. An imposing sentence in this case, the court appeared to focus on the injuries suffered by the victim, concluding that the guideline score of 7 to 23 months was not reasonable and thus not proportionate. Again, mind you, this was a guideline score that on the low end was 7, on the high end was 23. As the record shows, Mr. O'Brien's guideline score included 10 points under OV3 for bodily injury requiring medical treatment to a victim. Further included 10 points under OV4 for serious psychological injury requiring professional treatment to a victim. Additionally, 10 points under OV17 for an alleged wanton and reckless disregard for the life and property of another person. And then finally, 15 points under OV18, where the offender operated a vehicle when his bodily alcohol content was 15.15 grams or more. Your Honors, there is no question, there can be no question that the injuries suffered by the victim in this case were serious. Mr. O'Brien does not here seek diminish or minimize Deputy Peterson's injuries, but state only that his injuries are embodied, or included in the presumptively proportionate guidelines.
Counselor, can I ask you a question?
Yes, ma'am.
So are you saying that the nature or the extent of the injuries, because you could have a wide extent of injuries that would fall under the 10 points, can never be taken into consideration when choosing to go above the guidelines? Because a bodily injury requiring medical treatment could be a quick staple because you got a bad cut, or it could be something much more significant, as was indicated in the record in this case. And so is your argument that it can never be taken into consideration?
No, it can be taken into consideration. I guess the further question is whether or not reasons were given to justify the departure. Again, there's no question that the injury was serious. There's no question that the court properly considered the injuries, but I guess it's a question of degree. We start at one point, and then did this court, where we're dealing with guidelines of 7 to 23, where he gives the absolute maximum sentence of 40 months. Again, mind you, this is a fellow that pled no contest. Without going to the rationale for doing that, he didn't want to challenge this. He knew that he had messed up, and he understood that the injuries were serious. But the long and the short of it was that he didn't anticipate, that there would be this 40-month maximum sentence for an OWI third. The court failed, Your Honors, to justify the extent of the departure. Again, as I read the record, the focus essentially was on the injury or injuries. Severity of the injuries notwithstanding, the trial court, as I understand the law, was obligated to balance his sentencing factors with the circumstances of the case and the background and characteristics of the defendant.
I thought the judge acknowledged that addiction was a real problem. Was that not
He did.
done here? So it
He-
seems like the circumstances of the offense and the circumstances of the offender were discussed more thoroughly than I see in other cases.
I think to the extent the court discussed it, he made the point, and again, I'm paraphrasing based on my recollection of what the court's rendition was, but he basically indicated to Mr. O'Brien that, if the injuries hadn't existed, we would probably offer you the help that you need. And again, I think is generally, and I don't want to generalize, but I think is oftentimes happens when an individual has an OWI third, the sense of the court and the sense of the Department of Corrections generally is to get this person the help that he needs. Sure, is he going to pay a price? He's going to pay a price. But is the price proportionate to the circumstances of the case? In this case, we would submit that it wasn't. They clearly addressed the injury, but respectfully, I think the judge went way too far and exceeded the guidelines and did not, in my estimation, submit appropriate reasons for the extent of the departure. Again, the trial court was obligated to balance his sentencing factors with the circumstances of the case and the background and the characteristics of the defendant. Circumstances apparently not considered by the court include the conclusion that Mr. O'Brien's conduct, however illegal, was not the sole cause of the accident and Deputy Peterson's injuries. Although not raised as a defense in the trial court, the comparative negligence of Mr. O'Brien with that of the deputies involved in this accident is a mitigating circumstance.
So the challenge I think you're having with this argument is that the trial court did address that. And we're bound by the findings of fact that the trial court made unless they're clearly erroneous. And so unless you have something to say about those findings being clearly erroneous, which, as you know, is a tough standard on appeal, I'm not sure that this argument is going to be the prevailing one.
Your Honor, I'm not sure that the court addressed that. In my motion for resentencing, it was touched upon, but I think in terms of the court's rationale for the sentence, this issue of comparative negligence, and again, with all due respect to the court, I guess defendant is not here attempting to raise any challenge to his guilt. He pled no contest. He understands that. I guess there could have been an argument maybe at one point as to whether or not he should have had a trial and the issue of intervening events and whatnot. That was not the path taken. The path taken was that he pled no contest. Okay. And based upon that, the court imposed sentence taking into account, as he should, the severity of the injuries. But my humble opinion, and I would plead with the court that, there are limits and the individual perception of one judge doesn't bind or doesn't make the law in this case. Again, the guidelines are presumed proportional. People versus Posey, and I think the recent decision of the court in Circuit.
Once we have an established baseline of what the facts of the case are, I agree with you. Then we have to determine whether the sentence imposed based on those facts is disproportionate. What I took to be this argument you were just raising just now is that there were some facts about this case that the trial court got wrong, essentially, in terms of who was most responsible for what happened. And what I was suggesting is that trial judge looked at that, came to their conclusion about what those facts were, and it'd be pretty tough for us to say that's clearly erroneous.
Respectfully, Your Honor, I guess there are questions that go to guilt and questions that go to sentencing. My argument is that the issue of comparative negligence, the issue of intervening event, although not pled with regard to the issue of guilt, is raised with regard to the issue of sentencing. And again, as the court, has reviewed, these facts are extremely difficult. Again, to the extent that you have a patrol vehicle, two patrol vehicles and some other vehicles on the side of the road of two-lane highway and partially into the travel portion of the roadway. And as I recall the facts and videos, Mr. O'Brien was heading north and, apparently he had slowed down. He wasn't going in excess of the speed limit. My recollection of the facts is that, there was I believe it was in the state police report, a vehicle had passed the incident with the flashing lights and the deputies. Mr. O'Brien, normally people are going to attempt to avoid that incident, and that's your legal obligation. I think, when you have a situation where there are traffic lights and people are supposed to stop or avoid it, arguably it could have gone into the southbound lane, but apparently there was an indication of another vehicle heading down the southbound lane. So putting myself in Mr. O'Brien's eyes, he continues on having seen a northbound vehicle pass, and then unfortunately, the passenger door, the vehicle driver door of the deputy's vehicle opens up unexpectedly. We have the collision, and we have the injuries. Whether that in and of itself would have been an intervening event that would have potentially, had it been argued, would potentially have resulted, in an acquittal or I guess we'll never know that. But that's not the decision that was made in this case. But at a minimum, my argument is that it needs to be considered a mitigating circumstance. And in my opinion, the court failed to do that.
Anything else?
Yes, Your Honor, if I can just be very brief. Simply stated, the specifics of the incident do not support the prosecution's efforts to demonize Mr. Bryan. Again, I assume that, I was reading this record, and the prosecutor suggests that these facts support a finding of extreme negligence or depravity. That was the essence of the argument the prosecutor had in persuading the court to impose the maximum sentence. The record in this case supports findings that Mr. O'Brien was driving his motor vehicle, albeit illegally, at the date and time in question with a blood alcohol level of 0.15. Although his history, we're talking about his personal history, evidences an apparent alcohol addiction, which was referenced by the trial court. And again, with the trial court saying, but for the injuries, Mr. O'Brien, you would be an individual that we would be seeking out help for and get you the help. And these injuries could have been avoided. But you went beyond that and again, imposed the maximum sentence. Mr. O'Brien did not attempt to leave the scene. This is not the typical case where, you've got a drunk driver and he tries to run away. He stopped his vehicle. Okay. And he presumably would have offered assistance, but for the fact that he was directed by Deputy Armstrong, who was the other deputy at the scene, to get in his vehicle and stay there. The alleged unsworn observations of a booking deputy that Mr. O'Brien was laughing and giggling.
Yeah, but the trial judge said he wasn't going to consider that in that sense. So I think we got that. Listen, I think you've made a good presentation here, and we've got a lot to consider. But I think we've got most of what's in the brief.
Thank you, Ron.
Because we only do 15 minutes for people who don't have opposing argument. I think we're at about time. But if there's anything you'd like to say to wrap up.
Just finally, if I may, Your Honor, again, respectfully, we would submit, or I would submit on behalf of Mr. O'Brien, that the facts or circumstances of this incident simply do not justify the worst case scenario or a basis to exceed the presumptively proportionate guidelines and imposition of the maximum possible sentence. Again, I would, indicate to the court that the guideline, he's already exceeded in terms of incarceration, the high end of the guidelines by 2 months. And we would respectfully request that he be resentenced. And as it would be, in my opinion, unreasonable to expect Judge Bitzer, the district court judge sitting by assignment to the circuit court, to be able to put out of his mind previously expressed views and findings without substantial difficulty, and that Mr. O'Brien be resentenced by a different court, different circuit judge. Thank you.
Thank you very much.
Thank you.
That case will be submitted. The next case on our docket is item number 19, docket number 371955, People versus Adam Manley Dunn. Good morning.
Morning, Your Honors. Possibly good afternoon. David Herskiewicz appearing on behalf of Mr. Dunn, the defendant appellant in this matter. This has been briefed by obviously myself. Brother counsel's not here because they got their briefing late, but nonetheless, it's been thoroughly briefed by both sides. I'm going to try and keep it short and sweet. This case comes down to sufficiency of the evidence. It is, it's a bench trial. The court looked at the evidence. It is our contention that the evidence just wasn't there. And you have to take into account what was shown and obviously what wasn't shown. For instance, one of the key elements of this case was video. It's a Ring video doorbell, which we all know starts the minute you see motion on the doorbell. Yet the only time the video starts is once the complaining witness is on the ground. You see the defendant and the co-defendant on top of them. You do not see any shots being fired. You do not hear any shots being fired. There is just missing information here. The contention is by the complaining witness originally that he sees the defendant shooting him. However, at trial, he says, "Oh no, I didn't see him. I only heard gunshots. I don't know where the gunshots came from. Maybe he shot me through his jacket." If you look at the video, there's no hole in any of the portions of the jacket the defendant's wearing. You see no gun in the defendant's hand. The only gun seen in the video is that of the co-defendant. We just don't feel that there is sufficient evidence here to warrant a conviction. We ask that this court overturn the conviction and in honor of Passover, which we are currently in, let my people go and overturn the conviction, give them a new trial. Beyond that, I don't know if there's much more I can add that wasn't already placed in the brief. And I'll take any questions this honorable court may have. If not, I will pack up and go home.
Thank you very much.
Thank you.
That case will be submitted.
Have a good day, everybody.
You too. Okay, the next item on our docket is item number 20, docket number 371101, People versus Markel Outlaw. Morning.
Good morning, Your Honors. If the court has no objection, I do have my cell phone to time myself.
Mhm.
I can open it.
Of course.
May it please the court. I represent Markel Outlaw. My name is Jennifer Mead. Mr. Outlaw is present with us today in the gallery. Your Honors, we are asking the court to remand Mr. Outlaw's case for a Ginther hearing to develop factual record about trial counsel's discovery omissions, pretrial preparation, and other deficiencies. If this hearing and the briefs establish constitutionally deficient performance and prejudice, then we would ask for a new trial. As far as my main argument is ineffective assistance of counsel. clearly the governing laws are Strickland versus Washington, United States versus Chronic, and People versus Ginther. The first prong in any ineffective assistance of counsel case is the deficient performance. In this case, trial counsel failed to comply with the court's reciprocal discovery order. The first day of trial, counsel walked in and handed to the judge's clerk an exhibit list and a copy of the CPL application. Despite the court's very clear November 3rd, 2022 order that required all the exhibit list and the reciprocal discovery, trial counsel blew past that and gave no explanation for why he didn't provide that information to the prosecutor. Counsel also admitted that he did not know the requirements of MCL 28.425B14 while seeking the admission of the CPL application. It's a very important statute if you are going to be defending a CCW case. It's important for any trial counsel to know the statutes that are applicable to the case. And in this case, trial counsel admitted that on page 12 of the trial transcript that he had no idea what the requirements of that statute were. Trial counsel also failed to prepare the Mr. Outlaw for his testimony. Had proper time been spent with Mr. Outlaw in preparing him to testify with the knowledge of the relevant statutes and the exhibits, testimony could have been brought in that would have allowed for the court to give the Michigan Criminal Jury Instruction 11.14 regarding a lawful purpose for the transportation of the weapons in question. So those are the most dramatic of the deficient performance.
Oh, go ahead. No, you go.
please.
You go.
Okay, can you tell me what that evidence, had Mr. Outlaw had just the best criminal defense lawyer in the state of Michigan? What would the evidence have been, or what would that lawyer have done that could have changed the outcome in this particular case?
Well, just my first quickest reaction is if Mr. Outlaw had been properly prepared, well, first, if trial counsel had abide by the November 30th, 2022 discovery order and filed the exhibit list, tendered a copy of the application, that application was evidence that Mr. Outlaw was attempting to do everything in regard to possession and transportation of weapons properly. He attempted to get a CPL. The transcript shows there was evidence that the police officers saw on lien that there was a pending CPL.
Counselor, he didn't actually have a CPL. And so isn't that a necessary part of a defense to carrying a concealed weapon, that you actually have a CPL, not you're attempting to get a CPL?
Well, it was beyond the 45 days. And I recognize that Mr. Outlaw did not have the receipt on him, but he did have the weapons torn apart. He had the two pistols, which the pistols were why Mr. Outlaw is now convicted of 2 felonies. And as this court is aware, there's a vast difference between receiving a conviction for a felony versus a conviction for a misdemeanor. And had he received proper effective assistance of counsel, counsel could have laid out a full argument. He could have, I should say, he could have put the evidence on the record of when the fight was. How long of a different, how long was it between the fight that Mr. Outlaw had with his then girlfriend and him getting picked up by his brother? So how much time did he have to prepare to move these weapons? Did he ever go back? Was this was just a one-time move away? He never went back. He could have feasibly made a record that would have allowed for an instruction for the improper transport of the 2 pistols.
Now, for that instruction, there's a requirement that you transport the pistols in a container designed for firearms, something like that. And they were in the glove compartment. I think an argument could be made that if you lock the glove compartment, that keeps things safer, kind of thing. Makes sense to me. But the glove compartment isn't really a container designed for the transport of firearms. Without that, I'm not sure how the best lawyer in the world could have gotten that instruction for the jury.
Well, Michigan Criminal Jury Instruction 11.14 states, this law does not apply to a person who carries a licensed pistol in a vehicle for a lawful purpose. However, the pistol must be licensed, which it was, completely unloaded, which the 2 pistols in the glove box were unloaded, and in a closed case or container designed for the storage of firearms.
Okay, so you're saying that it was a closed case. Yeah, okay. So here I think one challenge, and I saw this argument in your brief. I appreciate it. One challenge here is that when you look at the jury instruction, you then have to go back to the statute that the jury instruction is about. And that statute doesn't have quite that same verbiage about closed case or container. It just says it just says it has to be a container for this designed for the storage of firearms. And so I appreciate actually what you've the interpretation of the jury instruction, and perhaps the writers of the jury instructions ought to go back to their grammar books and get this a little bit more clear. But I think the underlying statute really does require that the container, that you have it in a container designed for the transport of firearms.
But I think that an effective attorney would have at least laid the groundwork to have been able to make the argument. But when you have a defense attorney who doesn't meet with his client, who doesn't turn in an exhibit list, who doesn't provide the application to opposing counsel, you can't even get up to the base to try to hit. And in this situation, and there could have been a factual there could have been facts developed where the judge could have considered giving that instruction. And with that instruction, if that instruction could have been given, there would have at least been an argument that Mr. Outlaw should not have been convicted of the 2 pistols that were in the glove box, which would erase 2 felonies off of his record. And that criminal jury instruction, it also changes the burden, where the burden of proving beyond a reasonable doubt that the defendant was not carrying a pistol for a lawful purpose would be on the prosecutor. In this situation, there really wasn't a defense set forward. And every defendant has the right to a defense. They have the right to an effective assistance of counsel. I see that my time is running out and I don't want it to go.
Questions? Okay, thank you very
Thank
much.
you.
You'll have time for rebuttal.
Thank you.
Good morning.
Good morning.
Mitch Hibbs on behalf of the people. I just wanted to address 2 things that defense counsel said. First, as it relates to the CPL application, the court didn't only exclude it because it was late disclosed. It also did an analysis under 403 and whether or not it was relevant. And the court said, you know, there's no evidence to suggest that defendant actually complied with any of those restrictions that he would have had to do to use the application as his license. He didn't carry it on him. There was no evidence that he had an ID or a license, that he even completed all of the things for the application, such as submitting his fingerprints. So I don't think it's just as simple to say, well, had counsel disclosed this earlier, it would have been admitted. That's just not the case. I think the 403 and the relevancy analysis was still correct, and it wouldn't have made a difference. Also, as it relates to the jury instruction, counsel is disregarding the brackets of that instruction as well, which says that the gun has to be in the trunk of the vehicle and must not be easily accessible to the people in the vehicle. There's an unpublished case that suggests that the glove compartment's not even a container, you know, for vehicles. And that comes from
This car doesn't have a trunk, so you're at the second section. We can't force a trunk into a vehicle that doesn't have a trunk. So we're at the part about not being easily accessible.
In which case defendant testified that it was accessible because it was right in front of him in an unlocked glove compartment. And that's a requirement from the
Testified the glove compartment was locked. I don't know if the facts back that up, but I think he testified it was locked.
In any event, the glove compartment's not a container for the purpose of storing firearms, and it is still readily accessible regardless of whether or not it's locked. It's right in front of him. He was able to reach into it if he needed to. So I think that as it relates to either those substantive claims or the ineffective assistance claim, the record doesn't bear that out. With that, I'd be happy to answer any questions.
So if you have a CPL, or if it's been longer than 45 days and you have the fingerprint receipt, you don't have to put your pistol in a locked compartment, right? You can carry it.
If you were compliant, if it had been 45 days, so the application acts as a CPL, or you had a valid CPL,
Yeah.
then no. But I do think that in the carrying concealed weapon statute, it does say that you have to, you know, use it subjected to the restrictions upon those license. So if you're not using your CPL or carrying it properly, I still think that could open you up to liability. And which is the case.
You mean for a lawful purpose, for example?
Correct.
Okay. Now, on the second statute, the misdemeanor statute, is having a CPL a defense to that statute or not?
I don't think so.
How does that, does that run into any Second Amendment problems?
I think I touched on this a bit in the brief. I would still say no. I think that, you know, the state is allowed to restrict the way in which you carry a weapon, right? Howler says that, Bruin acknowledges that. And so the fact that you are still unable to carry a rifle in a certain way concealed within a car as an improper transport, I still think is consistent with the way that the, you know, guns have been regulated under the Second Amendment and would still be consistent and constitutional under Bruin and Rahimi. Because there is a way to transport that rifle properly in a car, right?
But not for self-defense.
And
my understanding is the CCW statute applies to pistols. And you can get a CPL, and as long as you're engaged in lawful activity, you're basically okay. And then this misdemeanor statute applies to firearms other than pistols, And this apparently was a rifle that was longer than the definition of a pistol, so it wasn't a pistol. But it doesn't seem like there's any, like if you want to transport that in a car, it's got to be broken down. You can't, there's just no circumstances. If I'm reading the statute correctly, I don't know.
Focus was more on the pistol, so I haven't really researched and thought about it. I do think that there's a question about transport and proper transport and whether or not that really reasonably restricts your ability to use a gun as self-defense, right? Is the Second Amendment saying you have to always be able to pull it out and shoot immediately? Or is it still some circumstances in which you would need to, lawfully transport it? And I kind of think that the CPL and the CCW is kind of the same idea, right? It is a reasonable restriction and there is a way that you could do that lawfully in a manner that you could do that. But I still think there's a possibility of transporting the rifle legally. And that's, I would argue, a reasonable restriction consistent with the historical tradition.
Anything else? Thank you very much. Any rebuttal? Okay.
The court was correct in that there's testimony that the glove box was locked. And yes, Mr. Outlaw testified that the guns were readily accessible, but I believe that leads me back once again to trial counsel not meeting with Mr. Outlaw and discussing the facts of the case. The glove box was locked. And what trial counsel could have and should have learned was that, and what's in the video is that the glove box was locked and the driver of the vehicle, Mr. Outlaw's brother, the owner of the truck, had the key to the glove box and he had to reach over and unlock it. So it isn't like Mr. Outlaw, as they're driving down the road, could just reach up, open up the glove box. He would have to do one of two things. He would have to break open the glove box, which is going to take him a few minutes and quite a bit, if that could be done. Or the glove box key would have to be taken off of the ring while it's being operated, or the truck has to be shut off, the keys removed, the glove box opened. Then once you open it, then the pistols have to be put back together again.
Do you happen to know how the police recovered the pistols during that search? I saw the videos. What, in other words, did they break open the glove box? Did the driver give them the keys?
Yes.
Driver gave them the keys.
They asked the driver to open it,
open
and,
it.
and
Okay.
then he opened the
Okay.
key for it. So that was the only way that they could get access to it. So I highly question whether the guns were easily accessible to him. He had to have that key and he didn't have possession of it. And so I think that had trial counsel taken the time and the interest in the case, there could have been more factual development, which could have created a defense for Mr. Outlaw. And I believe that the jury didn't get to hear everything. They did not get to hear all of the facts about how the glove box was locked. Where was the key? Defense counsel never went into who had the key. What would it take to open it? Did he actually have easy access? Why did he move out so quickly? Did he ever go back to the house? Those were all areas the trial counsel had a duty to present to the jury. And had that information been presented to the jury, there could have been a different outcome on the trial. And I believe that Mr. Outlaw's case should be remanded to the circuit court for a Ginther hearing to answer these questions.
Thank you very much. Thank you both.
Thank you.
That case will be submitted. We have one more before the time, before the 11 o'clock.
Oh,
We'll just do one more. Yep. All right. Calling the next case is item number 21, docket number 373698, Dion McKissick versus Rashonda Mitchell. And I believe we only have the appellant endorsed for oral argument, but you're here to answer any questions. Very good. Good morning.
Good morning, distinguished jurors. This is a case that we contend is based on an abuse of discretion that fell into set aside a default in this particular matter. And I think that I have to go slightly into some of the totality of the circumstances involving the facts in this particular matter. One of the things that we do know is that there's 3 statutes or 3 ways to pursue a dog bite case. In each one of those particular issues, you have to have a circumstance where there's an owner of the dog, somebody possesses the dog or has control over the dog. Our clients had none of that in this particular situation. So the issue about the dog.
If I can jump in, I think that that gets at the fact that your clients may very well have had a meritorious defense. I'm a little concerned about the lack of good cause on shown on this record.
Good. And I agree with that. And I'm prepared to address that because that's what the concern was of the trial court in this particular matter, because she didn't concern herself with the issue as it relates to the meritorious defense. She went directly to the issue as it relates to good cause. Now, we also know that the case law with respect to good cause, when you have a strong meritorious defense, as we had in this case, you can look for a lesser good cause. And the case law is clear with respect to that. So what happened in this particular case? And also I'll get to the totality of the circumstances test that we have now. But in this particular case, what happened? She receives a complaint. All the appellants have a complaint. They contact plaintiff's counsel indicating that, hey, we don't have anything to do with the dog, okay? So you could say, well, you should have read it, you should have answered. That would be too easy. They did what they thought was best, because sometimes you have a circumstance where an individual know that they're innocent of something, know that they're not culpable or have no liability, they contact counsel. That happens in the real world. So they contacted counsel. Then ultimately, what did they do? They received notice that the matter's proceeding further, because they had explained that we do not live at the residence. Here's our identification, provide everything to plaintiff. Then they received notice, and properly plaintiff gave notice. But you have to understand how we got there. In terms of them even receiving a complaint in this matter, none of the complaints were served to them at the location where the dog was. But they received notice. So what did they do when they get the notice? They log on because they wanted to be heard. And that's something different from just totally ignoring the process. They receive a complaint, contact counsel. They get notice of a court proceeding, they participate in the court proceeding. Then there was a situation where the mechanics of the court system, the Zoom system, didn't work right. And so then they were advised to get counsel. They said, get counsel. They did. As soon as they received that admonition to get counsel when they were online, they got counsel. And then there was no delay in filing the motion to set it aside. So the question becomes whether or not it was reasonable not to set it aside, whether or not it's outside of a principled outcome. I submit to you that it was. And so when you look at the issue that was raised at the motion, the issue came out, as we've indicated, that it was just about.
Which motion?
The motion, I'm sorry, to set aside the default. Yeah, what happened during the course of that particular argument? They confirmed that there was technical difficulty. Counsel for the plaintiff even mentioned that there was technical difficulty. This is how we get back here. And the technical difficulty, I'm talking about the Zoom, and that they were unable to talk. But in addition, they had the animal control complaint, which showed who owned the dog. So we ultimately get to a situation where they're going to issue a $1 million judgment against someone who clearly does not own the dog. So then we get to the situation as to whether or not this is a manifest injustice. Of course, it's a manifest injustice. Why would you give $1 million to someone who, or plaintiff against a person that doesn't own the dog? And then you look at, and this is why the case law talks about, if you have a strong meritorious defense, then why do you hold the person to the standard as it relates to their failure to do what they knew or should have known what to do? They didn't know any better. They did the best that they could. And so now we come before you and we look at a situation in terms of the arc of justice. We wanted to bend with some reason. And so that's why it starts talking about in terms of the standard in this particular case, whether or not the party completely failed to respond or simply missed the deadline to file. This is not like the situation where an individual comes before the court and he's on multiple occasions, he's show caused or admonished to do something and he does not do it, or counsel withdrew and then an individual is advised, you got 30 days to get a lawyer. What are you going to do? The person should get counsel. But when this person was admonished by plaintiff's counsel, and I applaud that, to get a lawyer, they did that. And then the other significant part about this particular case is the fact that it was just a default. It wasn't a default judgment at the time. And then when you also look at it, when you look at the standards, the default judgment issued, the last default judgment issued in July of 24. The motion is being heard in November of 24. The amended complaint in this matter was filed in March of 24. The reason I mention that is because in the civil docket, we're within the standard. They're within the 2-year standard of any jurist there. The person, and so now when he's trying to, or they're trying to set aside the default, we're trying to do that. We're still so close within the standard of 2 years. And then the other part about it is, it's so simple, and I don't know what the rush was in this particular case to get to the judgment in this matter when you already had the owner of the dog. A judgment was going to issue against that person. But the other part about it is, it's no doubt in anyone's mind that if an answer would have been filed, minimal discovery in this case, a motion for summary disposition would have been filed and it would have been granted. Because I can't conceive of any circumstance where it wouldn't be, because the principle is you have to show ownership, control of the dog, those particular factors. The elements of the offense would have, or the for liability would have never occurred in this particular matter. So we're at the default stage, not judgment. And then when you talk about 612 talks about what the time frame for filing a motion, even to set aside a default judgment. We're within a year. We're within weeks trying to set aside the default in this matter, not the judgment. And so when you look at the factors for 612, release from judgment or order, I mean, clearly we would have made that particular burden and satisfied that. But for whatever reason, it is indicated, and I don't know, and I'm not trying to cast aspersions about the judge for that particular day. Not that I know anything about the judge. I've been there before, and everything's okay. But I'm just saying, for whatever happened on this particular day, didn't have any more time. And like she says, well, I didn't hear anything about good cause, and nothing was done. Well, it was done. Because the parties
Let's talk really
participated.
quickly about the totality of the circumstances. You
Okay.
mentioned So first, whether the party completely failed to respond or simply missed the deadline to file.
Right.
When it comes to the complaint, there was a complete failure to respond. When it comes to the, when time came to enter the default judgment, there was immediate response, immediate appointment of counsel. But if we rewind all the way back to the start of this case, as it relates to your clients, the amending of the complaint to add them, there was not a response.
Yes, and so this is why the case law talks about, Your Honor, it talks about, so what reasonable steps did the person take? So a person who feel that I have no liability. So I contact the person who caused me to be served. This is not like some of the cases in the brief where a person comes into court and ultimately lies about service. They say, no, we got service. So did they take any reasonable act? And if a person is not culpable and not liable, they might call the law firm. That's what she did. All three of the appellants contacted the law firm. And that's how they proceeded with that. And then, as indicated, when they received notice for court, they participated in the proceeding. And they showed up because all they wanted to do was make the statement, hey, I think it's a mistake. I think it's a mistake. So they didn't go to a lawyer. They didn't know a lawyer to go to. If they would have been bit by the dog, they would have found a lawyer because all they had to do was turn on the TV. So there's nothing that says when you get sued and you have no liability, call us. That commercial's not out there. So they made an effort to do what they thought was right and contacted counsel. And counsel even ultimately gave them good advice. So the question was about the time standard. I mean, is this so overly late that they should not have had an opportunity to have their day in court? Because the question ultimately becomes, do we litigate the controversy in the courtroom, or do we have a technical defeat of an individual that is not liable? And that's what happened in this particular case. And they're still suffering under this particular judgment. One of them owned property, so they can't even file bankrupt because they would lose everything they had. These just working people.
So with respect to the rest of the circumstances and the totality of circumstances, so there wasn't a failure to, or there was a failure to reply to the complaint. The parties didn't completely miss, well, the parties completely missed the filing deadline, but to your point, we're doing things in their defense, like contacting plaintiffs' counsel. The duration between the entry of the default judgment and filing of the motion to set aside is very small.
There was no default judgment, just default.
That's right. Yeah, to set aside the judgment. That's right. So and there was no defective process.
No, we don't
okay.
make that, we do not make that claim.
And then the circumstances behind the failure to file or file timely, help me understand. So that's sort of like they tried to contact plaintiff's counsel and they only found out that was unavailing when they got the notice to appear.
Well, they ultimately received the notice of a default, and then they received information that a default judgment is going to issue. So they received the notice and they responded to it. And again, the only thing that they're trying to do is make a simple explanation. It's not our dog. And it was that simple. But when you look at the delay, even from failing to answer the complaint, that amended complaint was filed in March. And so then they get the notice of the defaults in May and July. And so at that point, they're still trying to act on it. Now, clearly somebody could turn around and say, well, the summons tells you have 21 days. Well, that would be real easy. Or do we do some analysis of the case law in this particular matter? Because in this particular circumstance, there's no judgment. And
With
it's-
respect to the case law, do you identify a case that's analogous to this where there was no responsive filing to the complaint, but it was still considered good cause?
Well, yes, all of the cases talk about that. They talk about no one filed an answer or took the appropriate steps to respond. So that's why we came from under the Shaw with the totality of circumstances. Then we have the case involving Barclay versus Crown Building case that's in the briefs. And that's the one that stands for the proposition that a lesser showing of good cause will suffice when there's a meritorious defense. But all of the cases talked about the fact that the other ones, that somebody didn't do something. So they didn't file an answer to the complaint. And if they did not file an answer to the complaint, they ultimately come before the court. And when they come before the court, they're trying to seek some relief. So they're trying to set it aside. So you get into the totality of circumstances. And so then that's what the prongs that you were just going over, all of those particular factors to see whether or not they can comply therewith and find some relief from the court. And I think when you look at what happened in this particular case in the totality of what went on, and then the strength of the affirmative defense, and I hate to keep reiterating that, but the strength of the defense in this particular matter, and then ultimately you just go to the basic principles about the fact that we prefer not to default a person, but give a person their day in court. So when you start doing those analysis that's been longstanding and been a part of the judicial system for forever, then you consider, well, what should we do? Is this a manifest injustice? Or does she just get penalized? Do the appellants get penalized because they went to court and tried to explain themselves, but they're not proper before the court? Court doesn't have to give advice, but the court, you hear it every day now because we're on Zoom, and we hear every motion day, if an pro per person is there, a judge will say, I think you need to seek counsel. I can't tell you what to do, but seek counsel. Because that help is not in the community. The help is in the community is for the plaintiffs. And it's for obvious reasons, and I'm part of it. But it's not for the person who is in the circumstance of my client. My client seeks justice. She should have an opportunity to have the default set aside. We should be able to answer. We should be able to file the motion for summary disposition, and they should be able to go on with their life. That's what I ask you to do in this case.
Thank you very much. Do either of you have any questions for Mr. Banca because he's here?
Not at this time.
I don't either. Thank you, Mr. Banca. Thank you both. That case will be submitted. At this point, we're going to take a brief recess and we'll come out shortly and resume at the 11 o'clock with the 11 o'clock call.
All right.
Okay. Thank you for your patience. We're back on the record and ready to move on to our 11 o'clock portion. Just a little bit behind here. We're going to go next to item number 23, docket number 372700, Mandy Benditelli versus Michelle Bertel-Sema. Good morning.
It's
Oh, good afternoon. Thank you.
Yes. May it please the court, Beth Whitman appearing on behalf of the plaintiff. So in this case, the trial court set aside a properly entered default and default judgment in the amount of a little over $3 million, not after finding that there was good cause and a meritorious defense, but finding that the complaint was illegally filed because it was filed prematurely, because it was filed before the 182-day notice period had expired. And as a result, the trial court made a legal determination that the complaint did not commence a cause of action, so therefore it could not support the entry of a default or a default judgment, and then also dismissed without prejudice the complaint in this case. So the trial court's decision here was error. We have a Supreme Court case that is directly on point. It may deal with the affidavit of merit requirement, but it's the same thing. It's the same analysis that we're going to apply here. Once you have a complaint that is filed, you have a default and a default judgment that is properly entered, it forecloses any argument that you have that there is a failure to comply with the tort reform requirements, whether it's the affidavit of merit requirements or whether it's the notice of intent requirements. It's still, you can't make this argument. This issue as to whether or not the complaint was properly, or I'm sorry, the action was properly commenced is now rendered moot. You have a default and you have a default judgment. The defendant cannot at that time then proceed with the action anymore.
So one thing I'm trying to piece together is that in some ways defendants did it right. They filed a motion and they said, we have good cause. They filed a motion to set aside.
Mhm.
We have good cause. We have a meritorious defense. And oh, by the way, after the default is set aside, we're also going to move for summary disposition
Right.
based on the premature notice of intent issue.
Correct. Yes.
So it was and then the circuit judge didn't bite
Yeah.
and did something else.
Yes.
And so what are we supposed to do? Can we analyze the good cause factors? Because those are not actually addressed in the briefs.
They are
here.
not,
We
no.
have the record.
We have
so
the record,
we see what
absolutely.
happened,
Yes.
But we don't really have the good cause stuff
We
here.
don't have a good cause analysis or decision by the court. We don't have a meritorious defense analysis or decision by the trial court. So I think what has to happen here is it has to be remanded back. The dismissal and the setting aside of the default and the default judgment has to be reversed. It has to be sent back to the trial court for this determination as to whether or not the motion to set aside should be granted.
And you're saying that you have arguments about why there is not good
That is
cause.
correct. And those arguments were made below as well. It's just not the basis that the trial court had ruled on. But, they had submitted an affidavit of meritorious defense by a podiatrist who said that they were in compliance with the standard of care. But I think they're going to have a big problem with good cause. I mean, good cause is, they didn't answer the complaint. They admitted that they had received it. They didn't answer it. They didn't respond or do anything once there was a default that was entered and it was served on them. The default judgment motion was served on them.
Ask you something? I
course,
mean,
please.
the arguments were put forth in the lower court pleadings.
Yes.
So can't we just look at the arguments that were put forth and
Absolutely,
preserved and then
absolutely.
make a judgment based on that?
Absolutely. This court absolutely has that authority. The arguments were raised. And I think that there is definitely a big problem, particularly with the good cause element of it.
We had the circuit judge done the analysis
Mhm.
and decided that there was good cause.
Yes.
We review or not, would we review that de novo or?
I think
for
that's an
abuse of
abuse of discretion. I believe that would be the case, that it would be. an
Because there's
abuse of
weighing
discretion.
different things.
Yeah, which he didn't do here. So
Right, we have nothing we don't have a exercise of discretion. to
that's
review.
exactly it. And when it's an exercise of discretion issue, then, when there's a failure to do so, that's a problem. So.
It's just that, it would be a lot of time.
Absolutely.
To do all of this, reverse, remand, all the, if it's kind of a foregone conclusion.
Yes. And I wanted to make the point too, they were served with a copy of the notice for the hearing on these the motion to set aside, or I'm sorry, motion for entry of the default judgment. It wasn't until they were served with the affidavit, the default judgment itself, as well as the subpoenas for a creditor's exam, that they actually did anything in the case. Obviously there's the jurisdiction issue that was raised by the defendant. It's a situation here, obviously there was a dismissal without prejudice, but the case law that the defendant relies upon here is, I think, completely different than the issue that we have here. We didn't attempt to stipulate to dismissal of certain claims without prejudice so that we could, circumvent trial court procedures or the court rules in order to get to this court. This is our time that we can actually challenge what the trial court did here. And we can't do that in a separate action, even if there is a dismissal without prejudice that would allow a separate action to be filed.
Was a separate action filed?
Not that I am aware of. I don't know the answer to that, though. The other thing too is that, obviously I included this in my briefing as well. Burton is a problem. Burton was wrongly decided. The entire basis for the trial court's ruling was that Burton required this to happen. I know this court is obviously bound by the Supreme Court's decision in Burton, but Judge Koropkin, I have a concurring opinion from you in the Brooker case that says there are significant problems with Burton, and the Supreme Court really needs to look at this. So that was just my anti-Burton spiel. So unless the court has any other questions, I will say the rest of my time for rebuttal.
I don't have anything.
Okay, thank you.
May it please the court, Ronald Letterman on behalf of the defendants to answer your questions to opposing counsel. Good cause was found by the trial court to set aside the default judgment because an action was not commenced. The trial court concluded that an action was not commenced. Since an action was not commenced, it had no subject jurisdiction or personal jurisdiction over this defendant. And the trial court, as a result, concluded that it had no choice but to dismiss this lawsuit because a default was entered improperly when an action was not commenced. So I take issue with Ms. Whitman's statement that a default was properly entered and that the trial court did not establish the existence of good cause before setting aside the default judgment. Given the fact that the action was not quote unquote commenced, there was no jurisdiction.
But I mean, I understand the logic of your argument, but doesn't the Supreme Court's Safian decision, I'm not sure if I'm saying it right, is that distinguishable or isn't, I thought the point of that decision was, no, you don't get to just not answer. You have to answer and then move for summary disposition under MCR 2. The one with the L.
In Safian, the defendant did not file an answer because of his subjective belief, erroneous subjective belief, that an affidavit that was attached to the complaint was invalid. And the Supreme Court held that an erroneous subjective belief regarding the validity or invalidity of the affidavit of merit does not constitute good cause. Here, we're not talking about a challenge to an affidavit of merit. We're talking about properly establishing the jurisdiction of the trial court, which by legislative mandate requires that the lawsuit not be filed until after the expiration of the 182-day notice period in medical malpractice actions. So for that reason, Burton is applicable and Brooker is applicable. Brooker itself specifically held that a statute of limitations is not told by a filing of a complaint before the expiration of the 182-day period because of the statutory language in MCL 600.2912B, which says basically that a person shall not commence a lawsuit before the expiration of the 182-day period. So because of that statutory language, Brooker held that a premature filing of the complaint does not, quote unquote, commence a lawsuit and may not serve as a tolling event for the purposes of the expiration of the statute of limitations.
Did you make this argument below? In the sense that when you filed the motion to set aside?
Yes,
Make this
we argue,
argument?
yes,
Okay,
we
so
argued.
I know you argued the good cause factors, and I know you argued the meritorious defense, but then it seemed like you said, after that, it seemed like you said, oh, and by the way, after you set aside the default, that's when we're going to move for summary disposition under Burton, which is kind of a little bit different from what you're saying now, which is essentially we didn't have to answer at all. We could have just gone on with our lives and never.
That's because we believed that we were not in a position under the court rules governing defaults to move for summary disposition at the same time as we were trying to set aside the default. So we did argue that in the alternative, but we did make it clear that the court had no jurisdiction because an action was not commenced. If an action is not commenced, then a default may not be entered by the plaintiff that failed to commence the action. We did argue that, and the trial court did latch on to that. We don't believe it was improper. But if the Court of Appeals would disagree with us, then I think that the proper remedy would be to remand it back to the circuit court for more complete findings with respect to whether or not good cause was established beyond the fact that the circuit court had no jurisdiction. There is an abuse of discretion standard by the Court of Appeals when you're determining whether or not a default should be set aside for the existence of good cause. It's not for this court to resolve that question in the first instance. But again, I don't think that the Court of Appeals need go that far. I do believe that the trial court's analysis was proper in recognizing the implication or the import of the filing of the lawsuit before the expiration of the 182-day notice period. The trial court found that it had no choice, no alternative, but to dismiss the lawsuit and set aside the default simultaneously. I did not feel the need to require the parties to come back on a motion for summary disposition to make the same argument when the court was faced with a mandatory decision on this issue. That's basically what our argument is substantively, and I'll take any additional questions.
Thank you very much.
Extremely brief. I just wanted to indicate the Safian decision, both from this court and from the Supreme Court. I think they implicitly rejected that good cause could be established through any sort of argument that there is a failure to commence a cause of action. In both of those cases, I'm sorry, in this court as well as in the Supreme Court, the defendant had made this exact argument that, because the plaintiff had failed to comply with tort reform requirements, there was a failure to commence a cause of action, and therefore the default was void ab initio. And both this court and the Supreme Court said, no, that's not the case. So
there's a tension between that and Burton.
And yes, there certainly is.
There are many tensions when it comes to this issue, but I think that is one of them, right? Is Burton seems to rely on the premise that the reason why dismissal is with prejudice, or why the statute isn't told, is because this legal fiction that you never actually commenced the action. Correct. And yet Safian seems to say, oh, but you still have to, even if they didn't commence the action, you still have to answer. And
Yes.
then wait until you're allowed to file a motion for SD.
Correct.
And then do that.
Yes. So it really gives deference to the fact, again, that there was a properly entered default in that case. So, and that's exactly what we have here. So it essentially makes that default, that default tantamount to any other challenge that you're going to have, whether it's statutory or court rules. And we see that in the Sanders decision as well. There it was a challenge to the compliance with 2.112L, which is the timing requirements for challenging the notice of intent. The court said, you have to comply with the requirements in the court rules to answer the complaint. Just because it hasn't commenced a cause of action, and that was a notice of intent case, it doesn't mean you don't comply with the answer to the complaint.
But that wasn't a default.
It wasn't a default
Yeah,
case.
okay.
No, it wasn't. It was a notice of intent case, but it was a failure to comply with a different court rule, 2.112. So that's all I have, unless the court has any questions. Okay, thank you.
Very much. That case will be submitted. Okay, calling item number 24, docket number 373-435, Rebecca Moses versus David Moses.
Good afternoon. Andrew Mahovlich appearing on behalf of the plaintiff Rebecca Moses. This case arises out of, as the court may have seen from the docket or from the submissions, a rather contentious and long divorce. It was filed in 2020, and that resulted in the entry of a judgment of a divorce that we are appealing from on November 7th, 2024, a year and a half ago. By way of brief background, just in context, Rebecca Moses entered into this marriage approximately $3 million of assets. She had invested along with her brother into various properties, fixed them up, resold them, and was quite successful. At the same time, David Moses essentially is running his father's property management company. Didn't really own a lot of assets or properties itself, but rather managed apartment buildings for other owners. The most obvious reason with respect to this appeal and to set aside the divorce judgment is right on the face of the judgment itself. And counsel doesn't bother in their response to even address those issues because I think it's so obvious that it's improper. The document itself is not a document that results from valuation of different assets, liabilities, any of the things that either an arbitrator or a judge should do before entering into a judgment of divorce. Instead, it is the form one-sided prepared by defendant's counsel of a consent judgment or settlement agreement that was then relabeled. In fact, the arbitrator, in this case, Kirchnell's, simply crossed off the word consent. The court relabeled it as a judgment of divorce. But somewhat amazingly, the body of the document itself reads like a settlement agreement. For instance, very first paragraph says, the parties having come together and reached a full and complete settlement agreement concerning all the issues of the above captioned case and having embodied the terms and provisions of this settlement agreement into a judgment of divorce with the intent of strictly thereby bound, evidenced by the signatures of both parties in respects to counsel appearing below. It then goes on, and not only are there not any signatures, it was vehemently objected to the arbitrator, to the court, multiple motions to set it aside, pointing these obvious issues out. The document then, and it's runs throughout what might read as a settlement agreement. It's not a settlement agreement at all. For instance, in spousal support, it states that spousal support is waived and non-modifiable. And case law, particularly MCL 552.231, it specifically requires whether an arbitration or before a court, spousal support, that waiver of modification of spousal support has to be signed and has to be in writing and agreed to. Not only again was this objected to, but specifically when the court held an open hearing and proofs were taken in support of entry of this judgment. Rebecca Moses testified under oath that she never agreed to this document. She didn't agree to any of the terms and provisions, and specifically, she didn't agree to waive spousal support modification. It goes on, statutory life insurance provisions waived. During the course of the divorce, we learned that David Moses had purchased between $2 and $4 million of life insurance policy using the marital funds or assets purchased. No information with respect to this document waives that. There's assignment of real estate, liabilities, the marital business, everything went to David Moses. Any liabilities were deemed either liabilities strictly of Rebecca Moses or joint liabilities, pension plans. There's a provisions like mutual drafting. One in particularly disturbing. The result of this judgment, again, it was a year and a half. It's been pending. We moved to stay before the trial court, and then we moved to stay also before this court. We're denied. There's been garnishments. Mrs. Moses lost her job. There's they without identifying what specifically it consists of. Garnishments were submitted for over $800,000, and they've been garnishing her wages, no spousal support, nothing. She didn't end up with a dime with respect to this divorce, and without any real explanation. There's a provision on non-dischargeability. This document provides that she waives any ability to discharge or file bankruptcy. That's a federal right that was just taken away. And again, it was objected to and never agreed to. One that neither the arbitrator nor the court had any power to do. It goes on, waiver of discovery, attorney's fees, liens, representations by the parties that they agree to be strictly bound, and they signed this judgment as their free act and deed without coercion, duress, or undue influence. It's not signed, it's not agreed to, but the judgment exists. Her wages are being garnished. It's been a year and a half. Counsel, in fact, then asked for an extension 4 times, and this has been moved even further, all the while, while pursuing garnishments, pursuing collection with respect to this judgment. So
If the arbitrator had taken a more careful editing pen, because I understand that the arbitrator crossed off the word consent, but then did not do a lot of other editing. But had words like waiver and stuff been taken out, is there a reason why this judgment itself could not have entered?
yes, one, there are provisions in here that just an arbitrator can't take away. The spousal support, non-dischargeability, bankruptcy, things like that on their face, waiver of discovery, waiver of peace, all kinds of things. But beyond that, fundamentally, the issue, and again, counsel sort of sidesteps it in his response to the allegations, is that there was no valuation of assets. There was no valuation of liabilities. And so what happened with respect to this divorce substantively is that there essentially were 3 phases of properties or assets that were being discussed. First, there was a batch of properties, about $1.5 million worth. And the parties did agree that those properties would be taken, and they agreed on a range of price, and that those properties would be sold. Now, it was learned subsequently that the properties were actually sold somehow to David Moses, or he handled the sales and sold them to somebody else, and that was never disclosed. But putting that aside, there was a second significant batch of properties, and there was an offer made by Rebecca Moses's brother and his group of investors, not Rebecca Moses. And counsel misrepresents that, in fact, Rebecca Moses made that offer. She didn't. Notwithstanding that, that offer was rejected because David Moses submitted a counter offer, which said, without detail, without explanation, that the separate company that was his father's company that he brought into the marriage had at first 1.4, then 2.2, then over $5 million of liabilities. Those liabilities, and this is really the heart of what's going on here. Those liabilities were identified, and again identified in counsel's brief, as liabilities to owners. Now, AG Management doesn't own anything, right? It is a property management company, right? All it does is collects rents, takes security deposits, and pays bills, maintenance with respect to apartments owned by third parties. What was disclosed, or at least partially disclosed, is that David Moses, for years prior to the marriage and during the course of the marriage, had been taking security deposits. That's a criminal act. You cannot take security deposits. You can commingle them with your own bank account, but you can't take them, right? And he had liability of over $2 million. Now, that liability, if it had been disclosed, what it was, how much it was, that liability would have been excluded, or his own personal liability that he brought in to the marriage, and should never have been included. Instead, what happened is that David Moses was given by the arbitrator all of the rest of the assets. And he was given so that he could pay off the 2 million, 1.4, it was a moving target of liabilities. A motion was filed at that time with the arbitrator, and the arbitrator was stated to the arbitrator, what is this? How can he just be simply awarded all the assets and none of this identified? And again, in a divorce, whether it's the arbitrator or the court, right? You have to value liabilities. You have to, and in order to value them, you have to identify them. This was never identified. So Mr. Schnells wrote, okay, you're right. These assets are only going to be temporarily given to David Moses so that he can negotiate the sale of the management contracts of AG Management for a price of not less than $430,000. Nothing happens, right? There's no accounting, nothing provides. We file a motion before the court. And finally, in the second motion, Judge Gant says, yes, you're entitled to an accounting. We didn't get an accounting. We never found out what this $2.25 million liability was for AG Management that should never have been included, right? We believe that, in fact, because of the nature of what this was, and frankly, because of innuendos of counsel during the court, that these were security deposits that were stolen by, taken. I believe it's criminal to take security deposits that are provided on behalf of an owner. They can be commingled unless there's a provision in the lease or something that says something different. But that's what this is. But it was never disclosed. So the question was, and we asked at that time, presented to Mr. Schnells, how does this make any sense? Why would you take $5 million of assets and all of a sudden pay off liabilities associated with this one company, put it in bankruptcy? If it's really insolvent, right? Put it in bankruptcy. And the reason it couldn't be put in bankruptcy, or they didn't want it put in bankruptcy, because it would expose Mr. Moses to criminal liability. He would have to tell us what these $2.2 million in owner liabilities were. And fundamentally, in a divorce, businesses have to be valued, right? There's no valuation ever of AG Management, in particular, no identification and valuation of the liabilities. It goes further. When this first batch of properties were sold, about $1.5 million net, those monies were placed with Mr. Schnells in his IOTA account. We learned that at various times, $100,000 at a time, Mr. Schnells was giving money to David Moses in order to meet shortfalls with respect to AG Management or meet these owner liabilities. We never, and on some level, this is perhaps one of the most troublesome issues. We asked Mr. Schnells, we asked the court repeatedly for an accounting. This is an IOTA account, right? What happened to the money? We learned subsequently that when receiver was appointed with respect to other properties, that it was all gone and the receiver was owed another $250,000. What happened to the IOLTA money? At a minimum, we should have received an accounting with respect to the IOLTA money.
So counsel, which part of the, 'cause we're in arbitration land here, right? So we have to have a statutory basis to overturn an arbitrator's award. Which part, and it can't be a factual disagreement, right? Which part of the statute allows us to sort of get into the.
No hearing, no evidence, and refusal to take on the evidence. And even with respect to a divorce, whether it's an arbitration or not, there has to be findings with respect to valuation, evaluation of the business, valuation of the assets, properties, and evaluation of the liabilities, or at least an identification of them. None of that was ever provided. And the result is that the court changed the title of a settlement agreement that we never agreed to and entered it as a judgment of divorce with provisions that were never agreed to nor could be statutorily waived. There should have been a determination. Mr. Schnell's at one point relented and said, no, this is just given to him temporarily and you're entitled to an accounting. We never got that accounting. What we got was a typed up, unsigned closing statement that we believe that was just prepared by defense counsel with no corroboration and nothing, everything redacted. When we asked for additional information with respect to that, we were told, well, discovery's closed. Well, how could discovery be closed with respect to a document that was just received that contains no detail that the arbitrator himself said that there should be an accounting? If it was not a material mistake, right, why did the court overrule the arbitrator and say, yes, provide the accounting? Yet no accounting was provided. And it wasn't even signed. It was a page-and-a-half document submitted by defense counsel. What should have happened is.
So let me interrupt you again, just to let you know, because only one side is endorsed here, we run a 15-minute clock. And
I understand.
You're there. So is there a final point you'd like to make before we?
There is. There is reference to the third piece, which is there were three properties, and an action was started claiming that Rebecca Moses had transferred the properties improperly. Those three properties were properties that were in her name. It was a rental property, a vacation property in Lexington, and the marital home in Huntington Woods. They were in her name and the mortgages were in her name. After that had transpired, Mr. Moses stopped paying the mortgages on those, and they were all in default and foreclosure. The liability was to her personally, and under the status quo order, she believed that it was her responsibility to save money for the marital estate. So she found a seller, found a buyer, and she sold them for $750,000, which was the exact amount of the outstanding mortgages to save that liability from the marital estate. There were accusations by Mr. Moses and then a receiver that was improper. A jury trial was conducted with respect to that.
I'm going to have to ask you to wrap it up.
All right. A jury trial was conducted in July of 2025. That jury trial found that Rebecca Moses did absolutely nothing wrong. A judgment in that was entered in December of 2025. So the issue as to whether she did something improper has now been decided by a jury before Judge Gant, and the jury determined, and Judge Gant entered a judgment that she did not.
Thank you very much.
Thank you.
I see Mr. Gonzato is here in case we have any questions. Do you have any questions?
I don't.
Okay. Mr. Gonzato, thank you very much. Good to see you. And that case will be under submission. Okay. Have a great afternoon. Okay, the next case is docket number 25, item number 25, docket number 375050, Fox Funding LLC versus Grow Green LLC. We do have both sides endorsed for oral argument. Let's see. Good afternoon.
Good afternoon, your honors. If it may please the court, Ryan Langston on behalf of the appellants. I request to reserve about 5 minutes for rebuttal.
Yeah, we'll ask you to keep your own time, but that's fine.
Thank you. Your honors, this case is pretty simple, at least as we see it. We see this as two issues, really. And we also already briefed everything, put the facts forward in our brief, so we rely on that. But what I want to kind of point out for purposes of this oral argument, we essentially have two different steps to this analysis, at least as we see it. The first step being that whether this foreign judgment can be domesticated here in Michigan. I don't think there's any serious debate that it can under the Uniform Enforcement Foreign Judgment Act and under case law. It says that clearly once it's domesticated, the foreign judgment is treated the same as a domestic judgment here. And basically in all respects, the foreign judgment is essentially now a Michigan judgment. So the question now becomes that second analysis, that second step, which is, does the trial court have the authority to review the enforceability of the judgment? And is there any reasons for justifying vacating it, setting it aside, reducing it in any way? And that's where the issue in this case comes up, is when we got to the circuit court at that point, there was no analysis of whether this judgment should be changed, modified, vacated, whatever, under 2.612C1F. We just simply didn't get anything, even though we brought that up in the lower court. Beyond that, there's, it's a pretty straightforward issue as we put them all in our brief. We see that as pretty simple two-step analysis that we just did not get here. That's warrants remanding this matter back to the lower court for
So
further
on that
proceedings.
second step, it seems like your arguments in favor of not enforcing or in favor of vacating the judgment are all around the differences between Michigan law and New York law, public policy type of considerations, maybe even some unconscionability type thing, those types of arguments.
Correct.
And that sounds to me like just kind of an end run around the full faith and credit clause. Do you want to address
Yes.
why? I mean, I know you've identified this court rule for relief from judgment, but that's really just a procedural mechanism. There's an underlying substantive question of whether a properly entered judgment from New York can be vacated on these types of grounds.
And I totally understand that. And I do get that there is a substantive issue here. And that's what appellee has put in their brief. They're basically arguing that, well, aren't we relitigating this case here in Michigan? I understand that that's what it appears to be, but you have to take a step back and look and see this is a foreign judgment that has been domesticated here in Michigan. We have clear case law. We have the Uniform Enforcement Judgment Act that says that once it's domesticated, it is now for all intents and purposes a Michigan judgment. And we have this court rule here that allows parties to come forward, challenge the judgment on what other grounds. And it even says right in the rule, any other reasons justifying relief. Now we put in our brief and, as we argue in the lower court, we have all these reasons why there's sufficient grounds to relief from this judgment. And at no point has appellee ever challenged. These are clearly usurious predatory loans that these merchant cash advance agreements, which not only violate the public policy and laws of this state, but now New York is radically changing its laws on the same thing. It's unfortunate that the original action in New York was brought a year or two before that some of these changes were coming across. We cite the Attorney General's case that was occurring in New York that subsequently settled. But to relate it back to the question that you're posing is, I get that it appears that we're relitigating this, but what we're really doing is taking the facts that have already been established in the New York case, and now we're bringing them here in Michigan and explaining to the court, this is the background to the case. And now we're taking this judgment, which is now a Michigan judgment, effectively. And we're saying, look, these facts do not justify enforcing this judgment here in this state against these appellants. I have nothing further really to add unless free to answer some questions from the panel.
Thank you.
Thank you.
You all have time for rebuttal.
May it please the court, good afternoon, your honors, me, Kalish, appearing on behalf of Vox Funding. I'm going to be brief, not to discount the gravity of this case, but because the issues are fairly straightforward. All the issues raised on appeal were fully litigated in the New York action. All parties had the benefit of counsel. The case was decided on the merits. And for whatever reason, the appellants did not choose to appeal the decision in the state of New York. They didn't exercise their right there. And the law is clear that under Article 4, Section 3 of the U.S. Constitution, and which is the full faith and credit clause, and the Uniform Enforcement of Foreign Judgments Act, that this court is constrained to accept, domesticate, and enforce a judgment entered in a sister state as if it were entered in the state of Michigan. And to suggest otherwise, I can't imagine what your docket looks like now, but if domesticated judgments from a sister state domesticated in the state of Michigan were then allowed to be re-examined under the prism of Michigan law to reach a different result, I don't know how you'd have time to hear any other kinds of cases, because it would open the floodgates to re-examine cases that had been fully litigated with counsel, final judgment, and none of the exceptions apply that would allow the circuit court, let alone the appeals court, to step in and say, wait a minute, in the New York action, there was no jurisdiction over the defendants or some other fairly narrow exception, and that does not exist here. The court simply doesn't have the right to revisit the issues raised in the New York action, which, by the way, were the subject of a counterclaim. The usury argument was the basis of defendant's counterclaim in the New York action and was fully litigated ad nauseum, because I've read the pleadings in the New York action, and everything that's raised before this court was fully raised and put before the trial court in New York. I'm happy to take any questions the court has, but to me, it's fairly straightforward. I would ask that the court not disturb the domesticated judgment in Michigan, allow us to enforce, notwithstanding the fact that this has delayed the procedure for a year, so that we have not been able to proceed on collection of the judgment. It's a multi-million-dollar judgment. I'm happy to answer any questions the court may have. Thank you.
Thank you very much. Any rebuttal?
Very briefly, again, we touched on the relitigating the New York case issue. Just to stress that, of course, this case was litigated in New York. We got to a final judgment on it. It's unfortunate that, frankly, my review of the pleadings that were filed on behalf of our client in the New York case probably didn't point out some of the law that should have been. Hoped for a different outcome, but and then Appellee's counsel mentions the appeal that in New York that we weren't able to pursue, but again, it was based on not being able to post security to pursue that appeal, because we have I believe a $3.7 million judgment between all the parties. And that, again, this is all based on 38% interest rates being charged on, frankly, predatory loans. So appellees had no chance to actually pursue this appeal in New York. So now we're here in Michigan, and we've had this this judgment domesticated here in the state. We're not challenging the domestication at this point. The law is pretty clear on that point. But now we're stepping into the second part of this analysis. We have the domestication, now we have the enforcement part. The enforcement part is we're looking at what is basically a Michigan judgment. Now, are there any grounds for relief from that judgment? And as we argued under 2.612 C1F, there are just grounds for relief from this judgment for all the reasons that it charges you serious interest rate, predatory loans. I believe we explained in our brief the stacking nature of these loans. Our clients would take out one loan, fall so far behind because of the high interest rate, he has to take out another one to pay it off. Falls behind in that, has to take another loan, stack them on. And he got up to 6 of these by the time this New York case came about. But what I'm trying to say is that all these factors should have came in at the trial court, and they should have examined under 2.612 C1F if there's grounds to justify relief from this judgment. But we never got that from the trial court, even though we specifically raised that issue. So that alone warrants reversal of the trial court and remanding this back down for further proceedings. Thank you.
Thanks very much. Have a good afternoon. That case will be submitted. Calling the next item is 2 consolidated cases. It's item number 26, and the docket numbers are 369690 and 373371. DJH versus GMB. Good afternoon.
Good, Your Honors.
So before you start, and I'm not sure if you were here at the beginning this morning, but we have a rule that in PPO cases, you should use the initials of the parties rather than the names of the parties. So as you're making your argument, please try to refer to the opposite party by initials or he or whatever, rather than use the name. Okay?
All right, thank you.
Okay, thank you. Please go ahead.
May it please the court, I am the appellant appearing on my own behalf. Thank you for allowing me to appear today. Prior to her judicial role, the judge of these proceedings drafted the deed adding the petitioner to the respondent's property, creating a tenancy in common. That's the source of this entire dispute. I requested disqualification for that reason, and the judge stated the time limits had expired for the attorney-client relationship, and she refused. The issue of the ex parte. The petitioner failed to meet the statutory requirements under MCL 600.2950A, was not entitled to relief sought under MCL 75411H, 75411S, and or 75411I. The court issued ex parte order stalking on threats to use and access of the property and force the sale. Petitioner was required to show specific facts. Immediate and irreparable injury, loss, or damage will result from the delay required to effectuate notice, or the notice will precipitate adverse action required by MCL 600.2950A12. Same mandatory requirement is also found in MCR 3.705A2, and it also requires the court to state in writing the specific reasons for the issuance of the order and state any willful acts of unconsented contact. The court made no findings on that. I cited Pickering, and the site addressed the continuance of the burden of proof and the continuance of the PPO. And the standard of issuance should have been at 697 for that. And citing Camp versus Camp, for the preposition of the property rights were implicated by the PPO proceedings. I acknowledge it's a domestic violence case. The more direct authority is MCL 75411H D, which expressly excludes conduct serving a legitimate purpose from the definition of harassment. Petitioner was not asking for protection, he was asking for exclusion. No tenant comment is asserting legal property right to access and occupy joint owned property as a conduct serving legitimate purpose under MCL 75411H1D. The conduct does not apply to the statute. CNN versus CEB
345 Mish Ave, 151, 162 for NW3D 759, 2023 to enter a PPO under MCL 600-29508. The court must find respondent engaged in conduct that constitutes stalking as defined under MCL 750-411H. And I'm asking that that be reviewed de novo. And then the 14,
Can I ask you a couple questions? Is that okay?
yeah, sure.
Okay. So first question, is there still an existing PPO?
Yes.
Because, okay, so it got extended again?
Yes, till October 31st, 2027.
Okay, so there was the one extension in the appendix that we have that was set to expire.
September 14th.
And so then that got extended 3 years?
No, that one got extended for a year till 2025. And then we just went to court in October and she extended it to October 31st, 2027.
So she did, no, 1 year extension. No,
Two
well,
more,
yeah,
to 27
okay.
over the property dispute. She's given me more time to file our petition lawsuit and a year to file. And then she explicitly directed it to me, a year for me to file and then a year for the process to happen.
So, that was one of my first questions, because the documents that we have are limited to, back when you filed, and just from the appearance of the appendices, it looked like it wasn't, it wasn't a PPO still in place. That doesn't mean it's moot, even if that were the case. And so it's interesting and important for us to know that there actually is a PPO and still in place. Okay, so my next question is, or is more of a comment. I noticed you started off by talking about the conflicts that the judge had, and that was well documented as well in your appendices. I will note, though, that you did not raise in your brief any argument with respect to her being conflicted out. So when we look to review, you do have 4 issues, but they're all on the meat of, should it have been ex parte? Should it have been allowed at all? Should it have been done without a hearing? Should it have been, and there's, you do address it a little bit in the facts, but there's no actual issue before us with respect to whether or not there's a conflict existing. So I didn't want you to feel surprise or concern when you see an opinion from this court and it doesn't address that, because we didn't see it in the brief.
Okay.
And then the third thing I wanted to ask was, so the ex parte, well, actually, I'll let you continue your argument and then
Okay.
yeah.
I believe on October 28th, after I filed the termination motion on October 28th, we had a hearing and I asked for an adjournment, and I did ask her to disqualify herself.
No, that's definitely clear in the record. I'm just
Okay.
saying so there's the headers with Roman numerals.
Okay.
With issue statements, none of them address taking issue with her declining to recuse herself.
Correct.
So that's not going to be something that this
Yep.
court addresses, even though you did provide some information about that
Correct.
to us. It's not an official issue before us. So I just wanted,
Correct. I wasn't arguing that
Okay.
one at this time.
okay.
And then the 14th Amendment tied, there was no notice given to me to decide to issue the ex parte that clearly stated threats were property dispute, and it's a due process violation with liberty consequences attached. The record shows the PPO was entered into leaving even before the judge signed it. So on my next argument about the improper ruling, my brief cited PC versus JLS in a way that it doesn't not accurately frame the central issue. PC versus JLS presupposes the court applied the correct legal standard when evaluating stalking conduct. That deference only exists within the legal framework, proper legal framework. It's issued PPO based on threats, use of access, enforced sale of co-owned property, use of police privileges, are entirely outside the scope of MCL 602.950A because the trial court applied the wrong legal standard entirely. So I'm asking for we be reviewed de novo instead of abuse of discretion.
And let me ask about the circumstances underlying that initial extension, because this subsequent extension isn't before us. There was some transcripts provided with DJH's testimony that said you had not stalked, harassed, or even communicated with him since the PPO was entered. So it was more a concern, maybe something will happen again. Am I misunderstanding the record, or was there more? What happened after the PPO was entered? My understanding was that communication fully stopped,
Correct.
and yet it's still being extended
Correct.
on the grounds of stalking and harassment.
For a
Even though
property
you're
dispute.
not-
For a property dispute.
That you have ownership of.
Correct. MCL 600-2950A authorizes one thing, relief from stalking under MCL 75411H, 75411I, and 75411A. It does not authorize a resolution of property disputes. A co-owner asserting rights to join on property is expressly protected conduct. Powell on real property states one co-owner may use and enjoy property owned in a form of tenants in common as if he were the sole owner, provided his actions do not prejudice the use and enjoyment of the property by the co-owner. The trial court's extension was conditioned on severance of tenancy in common, turning a stalking statute into a property forcing mechanism. The condition finds no basis for MCL 600-295A 50A and falls entirely under the scope, making it an error of law and should be reviewed de novo. CAJ versus KDT 339 Mich. App 459-464-984 NW 2D 504-2021 at 464. Defines the scope. Herbersky versus G 249 Michigan at 44-46-640 NW 2D.
Pam,
Yes.
we have your briefs.
Okay.
So I think we understand the legal citations that you have.
Okay.
Is there anything else that you want to emphasize that we just need to pay particularly close attention to? I think we can make the decision based on the brief and the argument that you've had so far.
Okay.
It's been very helpful, and I think we're probably okay.
Okay.
So thank you very much for
Thank you.
hearing.
Thank you.
Sir, because you're not endorsed for oral argument, we're able to ask you any questions if we have any. Do you have any questions? Okay. All right. Thank you very much for being here. And that case is under submission. We'll get an opinion out to you as soon as we can.
Okay, thank you.
Thank you, and have a good afternoon.
Thank you.
Okay, that case will be submitted. The next item on the docket is item number 27. Docket number 374277, People versus Nicholas Lee Trackwell. Good afternoon.
My name is Robert Tomac. I represent the appellant Nicholas Lee Trackwell. We have raised we've raised two issues here. I want to simply accentuate where we're coming from on our first issue having to do with
Is that the
no,
judicial
excuse me, the second
impartiality?
issue, having to do with no, I'm sorry.
We've got impartiality
Yeah,
and
yeah,
sufficiency
impartiality.
of the
Yeah,
evidence.
what I want to point out there is, I've listed in my brief the interjections or the questions that the trial judge put forth. And, but I just want to draw the court's attention to one situation. Now, at a point in the record, there was a situation going on in this house where my client was trying to get into the bedroom, and his significant other was trying to keep him out. And he alleges that he was trying to get his property, including the keys, ignition keys. And the prosecution successfully established that the particular keys that were in there having to do with the car, not the truck that he arrived in, that it was the car keys that was in the bedroom. And so it was not as though he had to retrieve those keys in order to leave the premises. And the prosecution successfully established that. But then you have the trial judge going in and questioning it on that point, and making a real effort, or a real point of it, accentuating it, and for the jury. In other words, doing the prosecution's job. So like I'm reading.
I think that's the question, right? I mean, the judge said, I have a couple of questions because I'm a little confused.
Well,
Now, if she really was confused, that's a legitimate reason to follow up. If she's just saying that as a rhetorical device and really wants to make a point to the jury, that's something else. And what's difficult, we don't have the tone,
yeah,
right? We're not there. We don't have a recording.
Yeah.
We just have the transcript.
Yeah.
And so we kind of have to go with, well, she said she was confused. And then after this colloquy, right, she followed it up by saying, that was my confusion. Okay. I didn't understand what was going on with the keys.
Yeah.
Now, I mean, maybe she's being
I could just feel it.
right. And maybe in the courtroom you could feel it, but we don't do that. Right. So
okay.
we've got the transcript and that's what we've got.
All right. All right. That's my argument. Thank you.
Okay. All right. Well, thank you very much. That case will be submitted. And we have one more case on the docket. It's item number 28, docket number 370324, People versus Maurice Ali Crisp.
Good afternoon, judges. My name is Robert Tomac. I represent the appellant Maurice Ali Crisp. And in this case, we've raised three issues, but I want to talk about the issue having to do with premeditation. I mean, obviously, he's in a first degree and he's in there for life, and this is a significant matter. A lack of premeditation could be shown. And I just want to point out, when the prosecution explains this get together that these people had, and there was drinking going on, and it was going on into the night, and they were bad mouthing the victim here. And the prosecution in the brief says, well, he said he's going to get back at him, or she did, or his girlfriend did, or they're going to get back at him. And then as the prosecution explains, the victim comes to the door and he immediately shoots him. I just want to, we've seen fact patterns where there's premeditation, there's planning, there's a grudge, they're going to wait for this victim and so forth. We've seen many of these fact patterns, but there's nothing like that here. There's no planning to take out a gun and murder this guy. I mean, they sure had it out for him, but I just want to accentuate that this lead up to the actual shooting, in our position is that didn't amount to premeditation. Thank you.
Great.
Thank you.
Thank
Thanks
you
for
very
waiting.
much. That case will be submitted, and that concludes the case call for this panel. Thank you very much. We're in recess.